Wait, please. It was a lordship indulgence to item 4 and 5 of the petition. Yes. These matters are pertaining to the insurance coverage, alleged insurance coverage issued to the ATM card holders. But we have taken consent from both the parties. There is some development. Yesterday I received a WhatsApp message from the Council for Respondent Bank. They have provided me with a policy. We are verifying it from the Mumbai office. Four and five. Mr. R.K. Bhatta, the Senate Council hearing on behalf of the respondent number 3, submits that he needs to take certain instructions from the Mumbai office of the respondent bank, respondent insurance company, as regards the issuance of the policy. Oh, it's that matter. And as such, seeks for an accommodation. List the matter again on how much? 2 weeks. 2012-2023. Okay. Would like to finish it this year? Fine. Obliged.
May I please item number 25. David is subject. So I'm for the petitioner. I'm praying for 3 weeks' time to file a reply affidavit in opposition Union of India.
Okay. The request of the Learning Council for the petitioner matter stand adjourned to be listed up to 6 months.
Okay. Item number 33. We have filed one affidavit today. That may be called for.
May it please, Lord. I take to mention item number 24 because the other side. In the last quarter, the Honorable Court directed to file the affidavit in opposition by the petitioner, but that was not filed.
You are for the
Petitioner. And my senior counsel, my senior petitioner is out of petition.
the request of the Learning Council for the petitioner matter stand adjourned to be listed after 6 weeks.
Okay.
Lordship, I beg to mention item number 38 from the daily list. Lordship, regarding respondent number 9, we have asked the petitioner to kindly provide us the correct address. He is an old age man and stays in Dehradun. So he is in the process to collect the correct address of respondent number 9. So Lordship,
Who is the respondent number 9?
Respondent number 9 is Lordship Sweta. Srimati Sweta Goyal.
Then?
Who is able to get the correct address of the
You don't know your wife's name. Is your wife?
No.
Who is he?
He is my daughter-in-law.
So, you don't know?
Kindly, he is in process to collect the correct address of the respondent number 9. So, Lordship, kindly allow us 2 weeks time to.
The Learning Council for the petitioner seeks for an accommodation of 2 weeks to obtain the address of the respondent number 9. This is the matter in the first week of January 2024.
May I please, Your Lordship? I beg to mention item number 46. Kindly pass over the matter for the.
Why?
My senior have some personal difficulties on the Lordship.
Review file against whose order?
Lordship order.
What is the review stuff for?
On the day when the matter was taken up, they were absent, Lordship.
Oh, they moved the division bench.
Yes, Lordship.
And then again came
Yes,
before
Lordship.
this court.
Yes.
And I should notice in this
Yes,
matter.
Lordship.
You file your reply.
I have already sent it for vetting, Lordship.
Okay.
Affidavit.
It's so and so. Ms. B.
Sharma.
B. Sharma, appearing on behalf of the respondents, submits that the affidavit to be filed by the respondent is in the process of being filed in a week's time, and as such, seeks for an accommodation. This is the matter again on 18th of December 2023. In the meantime, the respondent shall file their
If I beg to mention a writ petition for identity.
Huh?
Writ petition for identity.
Why?
It's a 2016 matter.
Huh?
It is a 2016 matter, Lordship.
Yes.
And it was last posted on 12/9/2022. After it's a land matter.
Admission.
Yes.
8th of December.
If I beg to mention item 6 of the daily, here, Your Lordship, we have misplaced the file.
Huh?
So we have misplaced the file, Your Lordship.
How can you misplace the file? You are for the petitioner.
Yes, Your Lordship.
How can you misplace the file?
Uh,
It shows the irresponsibility.
No, Lordship,
Then how can you misplace the file?
Lordship,
Because it's old.
we have shifted our chamber from.
Huh?
We have shifted our chamber from
So?
one place.
What to do?
Lordship, kindly grant us 2 weeks time to reconstruct the file.
This is the file. Yeah, we will impose a cost. How can you misplace a file? Tell me. You can misplace a file. Isn't that a property belonging to your client?
Yes.
Yeah. Impose a cost upon you, 5,000. What's your name? In your name. You pay.
Kindly allow.
My lord, I am for the IIT, my lord.
What is that?
IIT,
You are paying for?
my lord.
Okay. You have a copy of the writ petition?
Yes, my lord, we have.
Copy of
We
the
will give it to
affidavit?
you.
Give it to me.
Yes, ma'am.
We'll take it up. 2 o'clock. Your file is ready now. Next.
At number 48 and 49 for withdrawal.
Withdraw. Simple.
Liberty matter.
What liberty?
Liberty is necessary because some persons who had to be made parties, they were not made parties.
Who?
Private respondent. Only the government has been made party. But the main relief is against the private respondent. So there are some formal defects. In that view, we may be allowed to withdraw with liberty to file a test.
And
In item 48, regarding 49, I have nothing to say.
48 is what? 49 is without liberty.
No, normal. I cannot put this. I can put 9.
49 is there.
Yes.
48 you want to withdraw
Yes.
with liberty.
48 is my item. I want to withdraw that petition with liberty. 49 is my learned friend's case.
You are asking for issuance of a patta.
But yes,
How does the private respondent have any business of?
so because they are occupying our land.
So
and-
how can this court decide that?
and I'm submitting matter. Altogether, 240 acres of land have been allotted in the name of the present petitioners, that means we, and also in favor of them. So there is a dispute. They want that all 240 acres of land should be given to us. And our claim is that from that 240 acres of land, we should be given 106 acres of land. That is the letter communication of the government. So they are also necessary party. Because from their share, we will get 106 acres of land. That is our claim. What is the view of the court that would be decided by your lordship?
Mr. Amu Mahmood, the learned counsel appearing on behalf of the petitioner submits that there is a formal defect in the writ petition of not impleading the private respondents in the instant matter, inasmuch as out of the 240 bighas of land, the petitioners claim that they should be given allotment in respect of 106 bighas. However, as the private respondents claim the entire 240 bighas, without the private respondents being made a party, an effective adjudication cannot be made. He therefore submits that he may be permitted to withdraw the instant writ petition with the liberty to refile by impleading the private respondents. This court, taking into account the above, permits the withdrawal of the instant writ petition with the liberty to refile by removing the formal defect above mentioned.
Highly ordered.
49 is there. Yes, what is your case of 49? Tell me. Why should I trouble him with too many matters?
It is same matter.
No. What is your case? Tell me. What are you asking?
But in this case, my lord, Mr. M.K. Chaudhary will appear, my lord. Kindly take up another case.
From a perusal of the writ petition, it reveals that there are 59 writ petitioners. However, the court fee of only one writ petitioner has been paid. The learned counsel for the petitioner submits that the deficit court fee shall be paid on or before the next date. List the matter again in the on 3rd of January 2024. In the meantime, the counsel for the petitioner shall ensure that the deficit court fee is
Most of it.
Yet a matter of the personal appearance 1015. Mr. Das, matter?
Lordship, although in the last occasion, your lordship,
Item number 53.
You are the chief engineer?
lordship, we have a chief engineer.
Mister, you can hear me?
This
Can you hear?
This is Abbasi, Additional Chief Secretary for Water
Are you the
Resources
chief
Department.
engineer, water resource?
I'm the Additional Chief Secretary in charge of Water Resources Department from the government. Because the
Okay.
order said Commissioner and Secretary, there is no Commissioner and Secretary. It is directly under me.
I was informed about that aspect. Anyways, the fact is, why you have taken that land of the petitioner, and after that, there has been various communications or various instructions being provided by this court that the revised estimate has the estimate has been sent to the finance department. On the other hand, the finance department is saying that no such estimate has been sent to the finance department. What do you have to say?
Sir, actually, I examined this based on the direction of the Honorable Court. We had first submitted, based on the direction of the court of 10th October, we had submitted the the ceiling proposal to finance on 12th of October. 12th of October, when we submitted it, on 27th, it was returned saying that it requires to be submitted under a separate head. But when we again discussed with them, basically it required a financial concurrence. We resubmitted it with financial concurrence on 8th of November. And in fact, the ceiling for that has already been issued yesterday. So there is no problem.
So now you have got the ceiling.
Yes, so the 2,33,82,483 was the amount for the ceiling. That has been received yesterday, and of which I think the petitioner Asiruddin Ahmed's amount is 86,13,601. So it's been issued to Darang. I think within the next 4 to 5 days that payment should be made. That is it.
So on the basis of that, we expect that within 4 to 5 days, the amount would be disbursed to the petitioner.
Yes.
I'll record that aspect of the matter and we'll fix it again on 18th of December. I want the assurance from your department that the amount is released on or before the next date.
Yes. Okay. Okay.
Pursuant to the order dated 24/11/2023 passed by this court, whereby there was a direction to the Commissioner and Secretary to the Government of Assam Water Resource Department to appear through video link before this court at 10:15 a.m. The Additional Chief Engineer, Water Resource Department, submits that there is no Commissioner and Secretary to the Government of Assam Water Resource Department, and he submits that he is in charge and he is looking after the aspect, more particularly the impacts involved in, more particularly the case involved. He submits that the finance proposal, the proposal was duly submitted to the Finance Department on, when did you submit it?
12th of October.
On 12th of October 2023, which was subsequently returned and directed the Water Resource Department to submit a fresh proposal. And in the meantime, the fresh proposal was submitted, and on 28/11/2023, the fixation of ceiling has been made of an amount of rupees 2,33,82,483. In that regard, Mr. R.M. Das, the learned standing counsel for the Water Resource Department, has placed before this court the fixation of the ceiling, which is in Form C-Roman 5. The same is kept on record and marked with the letter X. X, Y, Z. Y, X, Y. Letter Y. The Additional Chief Engineer, Water Resource Department, further submits that in view of the fixation of the ceiling, the amount has already been now sent to the Darang. Mr. Have you sent the money to?
The ceiling has been issued. It will probably reach, because it was issued last evening, so it will probably reach Mangalore today. And it will take about a week or so to process and submit the bill. And sir, if I may intervene,
the ceiling which have been issued have been sent to Mongoldoy, to the Dorong, to Mongoldoy,
to Executive Engineer Darang,
to the Executive Engineer Dorong, Mongoldoy, and within 5 to 7 days, the said amount of the said entitlement of the petitioner of an amount of rupees 86 lakhs, where is that amount? 13,601 shall be released to the petitioner. So, taking into account the above, this court fixes the matter again on 18th of December 2023. This court directs the Water Resource Department to release the said amount of 86,13,601 to the petitioner as committed, as submitted by within at the earliest and not later than the next date so fixed. The Executive Engineer, Water Resource Department, Dorong or Mongoldoy? Mongoldoy is directed to file a compliance report as regards the disbursal of the said amount to the petitioner by way of an affidavit on or before the next date. The personal appearance of the Additional Chief Engineer, Water Resource Department. What is your name?
So actually, my designation is Additional Chief Secretary, Sayyidan Abbasi.
Your
Additional
name?
Chief Secretary, Abbasi. Mr. Abbasi, Sayyid
Yes,
and Abbas.
Abbasi,
I,
is dispensed with
Lordship, he is additional chief secretary, Lordship. In charge-
additional chief secretary
in charge water resource.
in
But-
charge
Water
water.
resource department.
সেইটো কৰিব।
Right.
Chief additional chief secretary in charge water.
Right.
As Abbasi is dispensed with.
Hello.
Okay.
Item number 50.
Yes. Yes, but how are you constructing on the private, on the public road?
Lordship, in fact, your lordship, that was never a public road, your lordship.
They say it's a public road.
Lordship, that's why, your lordship, we have already submitted a representation.
It is your road. It's your land.
Lordship, it is in my land. That's why your lordship will kindly, I want to place one fact, your lordship. Your lordship will find that your lordship, my land, your lordship, is the two of the petition respondents, your lordship. Our land is covered by new DAG number 539 and 541, your lordship. Now 539 and 541 is carved out, your lordship, from old DAG, your lordship, 600, 618, your lordship.
Then
Now, your lordship, this, if your lordship comes to page 15 of the writ petition.
yes.
Your lordship, this your lordship will get
What
your
is your
lordship.
name?
My name is your lordship, Holodhar, and your lordship.
Krishna Gopal Das.
Lordship, Krishna Gopal, your lordship.
Sonaram Kolita. Holiram Kolita.
Lordship.
Okay. You are paying for all.
No, your lordship, I am for Krishna Gopal Das.
Who is paying for other two?
I am appearing for the Holy
You are also constructing on the private road.
No,
I am the
he
brother
is-
of the respondent number 5. I am other side of.
You are not constructing.
No, he has, it is not in his, your lordship, it is in between the land of your lordship.
Original tag number, that is what. It is the original tag number that is.
My lord,
I will show it, your lord.
so far the respondent of the 6th is concerned. His name may kindly be discussed.
Why?
Because he is not a necessity. Because he is not
Why have you made him a party?
uh,
We impose a
we
cost.
say we are
Who is paying for 6?
I am appearing.
Okay. You pay him the expenses. You have made him a party, 10,000.
Yeah.
Yes. Next.
Lordship. Now, your lordship, page 15, your lordship. Your lordship will get, your lordship. This is the road they have talked about, they are talking about, your lordship. Pursuant to letter number so and so.
Tag
edition,
number?
your lordship. That's a remark column here at
Yes,
the bottom, your lordship. And
Already
pursuant to
there.
order dated so and so, the circle officer and the said letter, a plot of land residing 4.68 hours covered by DAG number 540. Your lordship will kindly hold DAG 698 and 31.16 are covered by DAG number 544. All 698 all is declared ceiling circle and reserved for road and roadside. Now, your lordship, my land, your lordship, our land is in the original DAG, your lordship, of 618. Now,
618,
618,
not 698.
not 698. And your lordship, how can your lordship the land carved out from a separate DAG come in between us, your lordship? And that's why we have submitted a representation before the deputy commissioner after coming to know about this, your lordship, mischief, your lordship, through this writ petition. We, your lordship, filed a representation before the deputy commissioner saying that made an inquiry.
You are
and
referring to which one? Which remark?
page
In
15,
Asmi's page 17.
lordship, page 17, your lordship will get it. অতিরিক্ত উপায়ুক্ত মহোদয়ৰ 14/11/91 ইংৰাজী তাৰিখৰ so and so চিঠিত হুকুম আৰু উক্ত চিঠিৰ চক্ৰ বিষয়াৰ ইংৰাজী তাৰিখৰ হুকুম মতে পুৰণা 658 নং দাগৰ 540 নং নতুন 540 নং 1.52 R আৰু 544 নং দাগ অংশ চিলিং চৰকাৰী কৰি ৰাস্তাৰ কাষ হিচাপে ৰখা হয়।
And where are you mentioning this 3.14 R
It is their case, your lordship.
3.14 আর নতুন 161856 দাগ
In fact, this 698 is your lordship around 150 to 200 meter away from our dag, your lordship. Land carving out from a separate.
So
dag.
where is your land? Where show me your land?
Your lordship, my land is your lordship at
You must have filed an affidavit.
your lordship. That's
For it.
my sale deed I have annexed, your lordship.
This is by purchase.
Purchase, your lord.
You have purchased. What is the dark number?
This is a sin pack, your lordship. My
You have purchased of patta number KP patta number 1206
lordship will get it, your lordship.
of dark number 559,
Lordship.
page 23. That is the sale deed. How many sale deeds you are having?
No, this is their sale deed, your lordship. Their sale deed I have annexed, your lordship, are obtaining.
No, where is your sale deed?
Lordship, lordship. Your lordship. I have a copy, your lordship, but I have not annexed it, your lordship.
Hmm?
I have not annexed it, your lordship. I have
Then how do you know that you are the owner of any land?
No, your lordship, that's it. That has not been disputed, your lordship.
No, that is what when the government is saying that you are constructing on their land.
No, your lordship, my land is 539.
How do I know?
I have made a, your lordship, there is a-
The statement is nothing to do.
and that fact has been admitted by the government, your lordship.
The recorded pattada of a plot of land of Iman of dark number Iman, patta number Iman. And it also has 2 figures of 20 building is located on is the recorded pattada belonging to dark number 539 of patta number Iman. The same village and it. Again in the official of Sonaram Polita of 591. Plot of land of
I have filed an additional affidavit, your lordship. There, your lordship, I have mentioned in details, your lordship. Para 2 and 3, your lordship.
I'll wear.
Filed by Krishna Gopal Das.
What did you say?
Para 2 and 3, may I read, your lordship? The deponent begs to state that deponent Krishna Gopal Das purchased a plot of land measuring 2/10 lashes covered by dag number 618 old and 539 new and patta number 413 old and 135 new and Sonaram Kulta by virtue of separation of patta in 1975 purchased a plot of land measuring 1 kotha covered by same dag and patta number of Krishna Gopal Das situated near Bhangagar. On the other hand, Sri one Sanjay Chabra, who is one of the directors and also represents the petitioner company, purchased 2 plots of land in the western side of the deponent land. Thereafter, Sanjay Chabra suddenly trespassed into the land. This is not required. Then para 3, your lordship. Then deponent begs to state that the petitioner encloses Jamabandi for the year 1991 in the aforesaid Jamabandi shows that the land under Dag number 540 new is the part of Dag number 698 old, and Dag number 544 new is also part of Dag number 698 old. Therefore, the land covered by Dag number 540 new and Dag number 544 new will be adjacent. Be it stated that deponent land was under Dag number 618 old, and as such, the land covered by 698 cannot come in between the deponent's land. This was my specific case. This is my specific case, Your Lordship. That's why, Your Lordship, from the very beginning, what I am praying, Your Lordship,
Yes,
let's make an
government-
inquiry.
What is your stand? Where is the construction being carried out?
In our affidavit law.
Huh?
In our additional affidavit law.
Where is it?
Page 26.
Page
26.
of your additional affidavit?
Lot.
Yes, what did you say?
Para 2 lot.
Para?
Para 3, subpara 2. In the revenue map, it is said.
What affidavit you are referring to? The affidavit dated? Affidavit filed by the, on behalf of the respondent number 3
Yes.
on 29/9/2018. Huh? Where is the paragraph you are saying? Paragraph 3 has nothing to say.
Para 2 lot.
Para 2. That
Pa-
save
pa-
and accept those
No, no, no,
statements.
Page 26. Para 3, subpara 2 lot. Subpara 2.
Of what?
Paragraph 3 lot.
Paragraph 3 doesn't have 2 paragraphs, sub para 2.
Your Lordship, that means that Your Lordship dated 22nd November. He is referring to. Page 26. Running page.
Running page 26 is filed on 29th of September 2018.
That is Your Lordship probably wrong. His innovation is wrong.
This is the government. They are
Last
affidavit.
affidavit filed by them.
Huh?
Last affidavit filed by them.
By whom?
By the circle officer. Respondent number 3. He is the reference.
When did you file?
Affidavit 22nd November.
Give me a copy of it. See? Your DAG is what? What is the DAG? 535.
539 and 541, Your Lordship.
No, your DAG is
539 and 541, old 618. New 539 and 541.
no. Where is that 539 you have?
My
Where is
additional
539? You have 539 only.
539, the other one is 541.
Where is that 541 you have? Show me that. You have stated that the
Lordship.
Petitioner purchased a plot of land measuring 2 kata 10 acres covered by DAG number 618 and 539 new and pata number 413 old and 135 of from Sonam. That is what you have said.
Lord.
Where is the other land?
The Sonaram Kolita purchased from me, Your Lordship, and then Your Lordship, when the ultimately Your Lordship new dagger created, my became 539 Krishna Gopal and Sonaram 541. This
Who is Sonaram?
Sonaram, Your Lordship,
You are representing
Lord.
3 and 4.
3 and
Sonaram is 541.
541. In between these two ducks, 540 and 544 has come.
535.
540 and 544.
Yours is 535.
539.
539. 539.
539 and 541.
539 and 5.
41.
In between there is 540.
540 and 544. And this was carved out from your Lordship.
Whose is this 540?
540, that's reserved for road, Your Lordship, they say.
And then who is constructing on 540?
They say that we are constructing on 540.
So
540 and
is
540.
540, you are not constructing on 540.
Lordship, what has happened here, Your Lordship? 539 and 541, Your Lordship, our duck, we have been, Your Lordship, for long, Your Lordship. That's when privately we have been by giving up some portion of our land.
I'm only asking you a simple question.
Lord.
Whether are you constructing on 540?
If your lordship will go by the affidavit of the government, we are constructing on 540 and
I am
540.
asking you,
Lord.
are you constructing on 540?
Now, as on date, your lordship, that road, your lordship, falls under 540 and 544, your lordship. That's the road.
Are you constructing on 540?
Lordship, that has not now.
That is not your land.
No, your lordship.
Let us make it very simple. You don't have any rights over 540.
No, as of now, your lordship.
As of now, at any point of time, did you have any right over
Yes,
540?
your lordship.
Where is
Because
that?
that was part of your lordship 618, your lordship.
I'm not concerned. Whether that portion, that is why you have not produced the sale deed.
No, your lordship.
What is the area of 535?
Lordship,
What is the area of 539?
539 and 541, your lordship, 2 bigha 10 less.
We are not concerned with 541. We'll look into later. What is the area of 539?
1 kotha 5 lecha, your lordship.
1 kotha 5 lakh. And 541 is?
1 kotha 5 lecha.
So that is total is 2
Two
kotha
kotha
10
10
lakh.
lakh.
But why have you mentioned out here? Kindly see paragraph number 2 of your additional affidavit. That Krishna Gopal Das purchased a plot of land measuring 2 kotha 10 lakhs covered by dag number 618 and 539. And oh yeah, then how is it possible?
I have purchased, your lordship.
You have purchased. How could it be 539 if the 539 only contains 1 kotha 10 lakhs?
Lordship, 539 and 549, your lordship. Originally, when we purchased.
Why have you mentioned out here dag number so and 539?
Lordship, initially, your lordship, when we purchased, it was
You
dag
purchased
number
as for 618.
618.
And in between that,
Sale,
was it a conjoined plot of land?
your lordship will kindly see this.
You have not produced the sale deed.
Sale deed I have with me, your lordship. I can, your lordship.
You have intentionally you have
No,
not
your lordship,
produced.
I will produce, your lordship, tomorrow, your lordship, if necessary.
No,
Because
no,
it is in Assam.
you know about this.
And
Why
that
haven't you produced?
that
And this dag is there 540.
lordship,
You are not here to challenge. So if you are constructing on 540, demolish it. Okay. And you pay 10,000 to him as cost.
lordship,
You have to pay cost of 10,000, Mr. Bhatti. 15. No, because unnecessarily you have troubled him.
Definitely, because at the time of filing this.
No. You should not. Now you cannot come up now and tell this court that no, we don't want him. You have engaged an counsel because of that. So we are direct you to pay a cost of 10,000. 15. You are a big company.
lordship, may I make one submission, your lordship? Your lordship.
540 is there. You have not challenged it. So if there is any construction on 530, demolish.
Lordship, may kindly see one aspect, your lordship. Tomorrow, if your lordship.
I am not on that.
No, your lordship will
You
kindly
have,
see.
you have filed 2 affidavits. You have not enclosed anything, so nothing doing.
Lordship will
Isn't it
kindly.
tomorrow?
Your lordship will kindly.
Tomorrow is not there. You knew it. Today was the matter.
Lordship.
And as such, I fixed it at the top of the list.
No, lordship, I am your lordship. It's your lordship will kindly see one aspect. Your lordship. Tomorrow, if your lordship, after your lordship, if we are possessing more than what is there in our sale deed, your
First of all, why haven't you not enclosed any document?
I will.
Your affidavit is not clear.
I have because your lordship.
Your affidavit is not clear. You say now that you have purchased 618 and 539.
No, your lordship, I have purchased 618, but subsequently.
And then why did you mention and 539?
Lordship, since subsequently it was your lordship become 539, that's why your lordship.
So if it became 539, but what is the area of 539?
539, your lordship, some one part, your lordship, by both your lordship, 2 kothas 10 lakhs.
No, I am not. Mr. Bhottakur,
lordship,
don't try to confuse this
No,
court.
no,
It is a very simple thing. Don't make it confusing.
Lordship may take it up tomorrow.
No.
This,
Absolutely. I'll adjourn it. Subject to a cost of 50,000 upon you. Because what you have done is trying to mislead.
Lordship, I have your lordship.
Yeah, it is absolutely, it's a misleading by the
Your
respondent of
lordship, I
court.
have in my.
Of this 50,000, pay 10,000 to Mr. NNB Chaudhary and remaining 40,000 to the council.
Lordship will kindly see, I have never in my life have tried.
No, this is absolutely. What is this statement out here? What do you mean there? Mr. Bhottakur, are you trying to tell this court that this is the manner in which you are doing? Do you say that dag number 539 has 2 kotha 10 lakhs of land?
No, your lordship.
Then
that's why your
why this statement has been made just to make it confusing?
No, your lordship, that is not.
Kindly read it.
Yes, your lordship.
Yeah,
But that
It's
is
not clear.
That is not.
This is only just for the purpose of
No,
confusing this law.
lordship, I apologize for that, but I have never, your lordship.
No,
I have
Mr.
never done it and I will never done it, your lordship.
No, Mr. Botago, this is absolutely uncalled for, and that too for a council of your stature.
Lordship,
This is not what
I
is being
apologize
done.
for
We
that, your
impose the
lordship,
cost
but there
upon
is
you.
no intention.
We'll ask this person to be personally present in the court as to why 340 proceedings should not be initiated again.
Lordship, I
I
pray
direct him
before
to
your
approve
lordship
it.
that your
This is
lordship,
not done.
that he is a very old man in sick.
Very well.
He's in bed.
Video link is there. Nowadays, I have it in video link. We'll have it in video link. What does he have to say? We'll have it in here
Lordship,
and ask him to
even
be
if your
present
lordship
because he has made a false statement
No,
out here.
it
It is absolutely a false statement
Lordship,
being made, Mr.
Lordship,
Botago.
lordship will kindly see your lordship. If your lordship any fault is there, your lordship, it is on my part as a counsel because I prepared it, your lordship, and he signed it, your
Then
lordship.
why did you make this affidavit? Having a practice of so long, are you saying that this statement is right? Paragraph number 2?
No, your lordship.
Huh?
I should have been more clear, your lordship.
No, it is not clear. It is wrong statement. You say that you have purchased 618. Have you mentioned out there that from that 618 it became 539, which is a part of it? No.
Lordship, your lordship, I should have your lordship.
Where?
Lordship, let me check it, your lordship.
Which is one
Because that
katha,
has
one
not
katha 10 lectures. And in fact, 540 was a part of 618, and as such, that 540 was in fact it was a conjoined plot of land. And during the resettlement operation, these things have happened. Have you mentioned?
That I
Yeah.
should have, your lordship. That I should have.
It should have been your submission out there. It
Lord-
should have been there.
Lordship, it should have been there.
Yeah.
It should have been there.
And why they are not right? They are very right. 540 is a public road.
No, your lordship, even in their sale deed, if your lordship find, your lordship, no road is shown in their boundary, your lordship.
Huh?
By the petitioners, your lordship, sale deed, if your lordship go through, your lordship, no road is shown in their boundary, your lordship.
Not necessary.
Lordship. That's
That
what-
is not necessary. Whether the boundaries out there, the schedule being mentioned out there would take over.
No,
What
your
is the
lordship.
contents out there? If the dark number is there, you know very well the Supreme Court judgment out there. If a property or even Order 7 Rule 3 categorically mentions that if a property or immovable property has been defined on the basis of certain numbers on the basis of assessments, then it would be done on the basis thereof. It's not dependent on the boundaries.
Lordship, kindly one aspect, your lordship.
If he
you-
puts tomorrow the boundary with him with next to Taj Mahal, would the Taj Mahal come out there?
No, Lord. That was
Don't make that
follow from your
submission
lordship's
something.
mouth, your lordship, absolutely. What your lordship, I am praying, your lordship. If your lordship, after making verification, your lordship, if they find that your lordship, we are in possession of more than what your lordship is there in our sale deed, your lordship, they can.
Mr. Bottakur, when they made it, 541 and 539, and thereby bifurcated to this land, in between they have brought in 540.
541 and 540.
I'm concerned with 540.
540
If they
and
have-
544, your lordship. Both.
I'm not concerned with 544 now for the purpose, because if you see the map which has been filed by him in his additional affidavit, it categorically shows that 539 and 541 is bifurcated by 540.
Lordship.
And there is in between 540, but you have not challenged the creation of this new dark by 540,
Lordship.
which means that it is a portion of your land which has been taken if we accept your submission.
Lordship,
But that has not been
when your
challenged.
lordship, I came to know through this affidavit, your lordship, I immediately submitted a representation before the deputy commissioner, your lordship, which I brought by way of an additional affidavit, your lordship, saying that this is the fact, you make an inquiry and thereafter take action.
Which additional affidavit? This one?
No, your lordship.
Which one?
Yes,
Show me
this
that.
additional affidavit.
Then can this be the additional affidavit, which is a very confusing one?
But your lordship,
Where is your statement out there that 618 was a compact plot of land, and as such, out of that, 540 and 539 and 540, if it is made, it could have been very well made. But in between, there is a road has been inserted, and as such, that is wrong. Where is it? Where have you put to challenge that?
by your lordship filing a
And where is your representation? Let
That-
us see.
that is
To the
the
Deputy
page,
Commissioner.
page your lordship will get
I
it, your
purchased
lordship.
a plot
Page
of land
4.
of 2 kata covered by dark number Iman, again 539 new. Here you see what you are saying.
Your next,
618 oblique 539 new means 618 corresponds to 539. Isn't this the what is been mentioned at paragraph number page 78?
Next page, next line, Your Lordship, and the petitioner number 2 by virtue of separation of 4919 have purchased a plot of land measuring one kotha 0 lesser covered by the same dike so and patta number so during 7 days. Both the plots stand near the Bongagar having Rajguru Road in the eastern side.
Understood. So these are two plots of land.
Lordship. Subsequently, Your Lordship.
So how much land did you purchase actually?
Entire plot of land, Your Lordship, is
How much land you purchased?
that's Your Lordship. Initially, Your Lordship, 2 kotha 10 letters.
So if we are concerned as regards respondent number 3 or 4,
Lordship.
only 2 kata 10 letters.
Lordship.
And did you sell it to the respondent number 4? Respondent number 5? For whom you are representing?
Lordship.
You sold it.
Lordship.
How much did
I
you sell?
have, Your Lordship, one sale deed that's belonging to two sale deeds I have, Your Lordship, both. Your Lordship, give me some time, Your Lordship. I will, Your Lordship, explain, Your Lordship.
And 10,000 cost. To give him time, subject to payment of cost of 10,000 by him to the registry, to the legal services authority, and you 10,000 for unnecessarily impeding. This court, by an order dated 23/11/2023, had fixed the instant matter as the first item today, taking into account that the specific case of the made by the petitioner as well as the respondent circle officer, to the effect that the petitioner, respondent number 4 and 5, are constructing over the land belonging to the government, which falls in dark number 540 and 544.
Constructed. Already constructed.
Have constructed
Yes.
a wall on
Not wall.
belonging.
Exactly not the wall. In their subsequent affidavit, they mention, my lord. May I read it, my lord? As per the land record, measuring
I'm not on that, mister. Your submission should not be directed to remove the brick wall. Constructed a brick wall at dark number 540/544, which belongs to the government. Full stop. Mr. S. Bhattacharya, appearing on behalf of the respondent number 4 and 5, submits that submits on the basis of the additional affidavit filed by the respondent number 4 and 5 on 11th of March 2019. This court have duly perused paragraph number 2 of the said additional affidavit. Which, in the opinion of this court, does not clearly portray the actual picture. Inasmuch as a perusal of paragraph number 2 of the said additional affidavit and read with the representation enclosed as annexure AA to the Deputy Commissioner Kamrup, the aim appears to be in conflict. Mr. S. Bhattacharya submits that he may be permitted to bring on record the sale deeds on the basis of which both the respondent number 4 and 5 claims title over the lands, and as to whether any patta has been issued to the petitioners during the new settlement operations. For the ends of justice, this court grants 2 weeks' time to the petitioner, to the respondent number 4 and 5 to do so. During the course of the hearing, Mr. O.P. Bhatti, the learned counsel appearing on behalf of the petitioner, submits that the respondent number 6 may be struck off, as he has nothing to do in respect to the instant dispute. Be that as it may, a perusal of the writ petition, however, reveals that there are allegations being made against the respondent number 4. That the respondent number 6 have also, in conjointly with the respondent number 4 and 5, were constructing the private wall. This court, thereupon, on the basis of such allegations, have issued notice to the respondent number 5, 6 also, for which the respondent number 6 is now being represented by a counsel. The record further reveals that there has been nothing which has to show that the respondent number 6 is involved in the instant dispute. Therefore, for unnecessarily harassing the respondent number 6, this court imposes a cost of rupees 15,000, 10,000 upon the learned counsel, upon the petitioners to be deposited before the registry of this court on or before the next date fixed.
Hello, I will say direct.
No. And upon depositing the said amount before the registry of this court, the counsel appearing on behalf of the respondent number 6 shall be at liberty to file appropriate applications seeking release. The registry shall thereupon release the said amount to the counsel for the respondent number 6. List the matter again on 20/12/2023.
But
At number 1,
Yes, madam.
Your Lordship, in this matter, we have lost complete communication with the client.
Status of eviction because initiated and whether they have been. Yes,
Lordship, they were all evicted, Lordship.
Evicted?
No, evicted, Lordship. No one, few of them were there, Lordship. But encroachment has been cleared by the district.
and the other matter both.
Other matter, Lordship, disposed of.
This is disposed of.
Because they are the lacies, original lacies there.
The instant writ petition has been filed by the petitioner. Challenging the eviction of the petitioners from the new daily hawkers market at Tinsukia by the respondents, as well as for a direction to allow the petitioners to continue to operate in the new daily hawkers market roadside without any interference from any quarters. Or in the alternative, allocate site/location for operating the new daily hawkers market. It has been submitted by Mr. S.S. Roy, the learned counsel, appearing on behalf of the government respondent state.
Respondent number 2.
Respondent number 2, that the petitioners have all been evicted and evicted why?
Because they are encroachers, Lordship. The district administration have Encroachers of the footpaths allotted.
were evicted as the petitioners were encroaching upon the footpath of
Of the
which road?
GNB road, the main Tinsukia GNB road, Lordship.
Which road, madam?
GNB road.
GNB road. You must have filed an affidavit. I've seen something.
Lordship, the municipal administration has filed the affidavit.
Whoever it is. Were encroaching upon the public road and footpaths. The learned counsel further referring to paragraph number 7 of the affidavit filed by the respondent number 1 submitted that the petitioners had no right to carry on any hawking business on the public road and footpaths. He submitted that there was a report of the respondent number 2 that the petitioners had manifested several endeavors for allotment of an alternative place to operate the street markets. And the Tinsukia Municipal Board had asked the wayside market holders to shift their business to an alternative place chalked out by the municipal board authority. But the said street hawkers did not comply and encroached the road arbitrarily. Taking into account the above, this court is therefore of the opinion that encroaching upon the road or the footpath and to carry out one's business is not permissible. And accordingly, the eviction of the petitioners from the footpath as well as the road by the respondent district administration cannot be interfered with. Be that as it may, this court, however, finds it relevant. Hello, Street Vendors Act. To take note of the Street Vendor bracket Protection of Livelihood and Regulation of Street Vending bracket close Act 2014, which mandates which was an act enacted to protect the rights of urban street vendors and to regulate street vending activities. The provisions of the said Act of 2014 stipulates the regulation of street vending, including the issuance of certificate of vending, as well as the rights of the street vendor upon issuance of a certificate. In the opinion of this court, the petitioners herein would be at liberty to approach the respondent authorities, more particularly the Tinsukia Municipal Board, in terms with the Street Vendors bracket Protection of Livelihood and Regulation of Street Vending bracket close Act 2014. And this court further observes that the observes and directs that the Tinsukia Municipal Board shall do the needful upon being approached by the petitioners or approached by the petitioners as per the provisions of the said act. But above the instant petition stands disposed.
Obliged. At number 2,
Mr. Roy, I have delivered one judgment on this street vendor,
Your Lordship.
more particularly as regards this SS road. Na?
SS Road.
It went there.
Lordship.
How it is to be done means you can't give what is required is you have to give them a place,
Lordship.
and not in a place, a certificate has to be given, and the certificate also has to give. So where are they going to vend? Not only that, allocate a place. You may give it. Just for example, a person may be given an allotment or from 8 to 12, 8 to 2, and the other person on the same area can be given from 2 to 8. This is how you regulate. If you don't regulate, you know what is going to happen. Nowadays in Guwahati, you can't walk around.
My instruction says the alternative place has been given to them.
No, anyways, but I think you have to have vending zones.
May I plead on that? So in this case, Lordship has directed to file affidavit. Today, my affidavit is ready, Lordship. Today, I will file it.
You are paying for PNRD?
No, Lordship. I am Health Department.
You have to help.
Yes, 1, 2, 4, and 5. Just now I have received after that.
What is the matter about?
One patient
Oh,
died.
this one.
Yes. Compensation claim. Today,
Okay, Miss S. Sharma, the Linen Council, appearing on behalf of the Health and Family Welfare Department, seeks for an accommodation, stating inter alia that the affidavit to be filed by the said department is ready and will be filed during the course of the day.
yes.
This is the matter again on 13th of December 2023. In the meantime, the petitioners would be at liberty to file the reply to such affidavit to be filed today.
Yes.
Filed by the petitioner, Respondent, Health and Family Welfare Department today.
That is your lordship. We need some time for instruction of the petitioner lordship.
Huh?
We need some time.
For what?
Instruction from the petitioner lordship, whether matter is infectious or not lordship.
How can you have any right out here in this matter? What are you challenging?
Lordship,
My lord, see your last order, your lordship.
Yes, I have seen that. I was supposed to dismiss it.
She's a scheduled caste candidate, my lord. She's claiming her right. She has married to general caste.
Huh?
The petitioner herein claims to be a scheduled caste, and she has married a general caste. Now the authorities are not recognizing her, and therefore she has filed a representation to the deputy commissioner, my lord, for identified her as a scheduled caste, and for makes necessary changes in the electoral roll. Therefore, my lord, we had submitted at the election
Directing the
commission.
respondent to correct the surname of the petitioner as Das in place of Bose in the current voters list for so and so, and to treat the petitioner as a scheduled caste candidate for all. But madam, you do one thing. This petition as such cannot give you the relief. You have to make the, who makes that in the panchayat rules, tell me? They, as per, you are making the state election commission a party. State election commission has no business out there. The electoral rolls are made by the election commission of India. And with the election commission of India, it is being done under the aegis of the chief electoral officer. And the chief electoral officer has to do it. And these election officers will do it. The particular election officer has to be made a party. You want the change in that. But how can you get a relief what you are asking for? Tell me, how can I ask him or them? They can't do anything.
Whole matter, my name is not there, lordship. Just
This was, therefore, don't appear.
not
They only,
I was supposed to dismiss the matter today for default.
Lordship, only pass over for the day.
Why? Cost?
My senior will
Where's your senior?
Mr. A.M. Barbuya. Mr. A.M. Barbuya.
A.M. Barbuya. A.R.
A.M.
Yeah. Ask him to be present. We dismiss this matter. This matter cannot see tomorrow's sun. None appears on behalf of the petitioner on call. It appears from the perusal of the writ petition that the petitioner has filed, from a perusal of the writ petitioner, including the relief sought for, that the petitioner have sought for a direction upon the North Guwahati police station to register an FIR against the security personnel of IITG, as well as to direct the IITG to review the security protocols and to pay compensatory amount of rupees 50 lakh. As regards the direction for registration of the FIR at North Guwahati police station, it is the opinion of this court that, taking into account the judgment of the Supreme Court in the case of Sakira versus so and so, reported in 2004. The petitioner would be well advised to approach the court under section 156(3) of the Code of Criminal Procedure of 1973. As regards the direction for payment of compensation of rupees 50 lakhs, the same cannot be adjudicated by this court under Article 226 of the Constitution. Accordingly, this court therefore finds further to that, this court is not inclined decide this aspect of the matter in the proceedings under Article 226 of the Constitution. However, grants the liberty to the petitioner to approach the appropriate forum. Further to that, as regards the relief sought for, that there has to be a direction to the respondent IITG to have better security personnel. The same cannot be decided without any adjudication of facts as to whether there was negligence on the part of the security of personnel. Accordingly, this court doesn't find any ground for entertaining the instant writ petition, for which the writ petition stands dismissed. However, the liberty is so given herein above. However, the petitioner shall have the liberty as given herein above.
7.
Yes.
Last occasion was the Lorette Council for the department
short term time for filing affidavit as to why, what is compelling them not to carry out their own order,
What do you want?
the order of demolition.
Huh?
7. There's an order passed by the GMDA.
You're asking somebody's license to be set aside.
Sorry, my item number 9. I'm not here. Item 9
You're too anxious. This is item number 7. None appears on behalf of the petitioner on call. What is your instructions? The respondent, although notice has been issued by this court as far back as on 28/9/2018, there has been no notice has been issued as far back as on 28/9/2018. The respondents, more particularly the official respondents, have no instructions. List the matter again in the second week of January 2024. The Mr. N. Goswami, appearing on behalf of the respondent authorities, shall ensure that the instructions are received, are placed before this court on the next day, as to why the respondent number 6 was issued the license for the fair price shop.
And number 8.
May please your lordship. Lordship, before my learned senior friend starts lordship, and first time I am appearing in this matter for the railway department, your lordship. Lordship, there is no affidavit has not yet been filed, your lordship. Affidavit has not yet been filed.
Why?
The 2000 lordship, there was change of council's lordship, maybe lordship, and
We are appearing for whom?
railway department lordship as a central government council lordship.
Earlier, Mr. A.K. Pulkas
Yes, sir, you are
appeared on behalf of the
study
railways and
council.
sought for time in 2019.
Yes, lordship. Then thereafter, lordship, all the cases have been transferred to the central government council, lordship.
Then?
Lordship, I am not paying a time, lordship, may consider the matter.
How does it make any sense?
On the aspect of the facts, your lordship. Lordship, it may things, lordship, then affidavit is required, then I will pay 3 weeks time, your lordship. Otherwise, lordship may pick up the matter also, lordship.
You are running the tea stall at Dimapur.
Yes. Yes.
And that has been what? What has happened?
Still running.
The tea shop is still running.
Then? Why have you filed the material?
While at that time I was not the ingress and egress to the stall was my lord blocked, and therefore I had come before the shop.
Now?
Now I'm not.
So, what remains?
Due to the interim order, lordship, they are running, lordship.
Interim-
It's an interim order, lordship. What happened, lordship? They have the
Interim
father.
order remains at page 64.
Interim order from the Guwahati High Court. Am I right?
What you are challenging with construction?
My lord, at page 64, my lord, annexure 6.
Yeah. What is your right?
My lord, since 1950, my lord, since my grandfather, my lord, we are running the stall. Now,
Stall where?
In Dimapur.
in the
Railway
in,
station.
in the Dimapur railway station.
Take your seat. You have no instruction. Sit down. Yes.
In the Dimapur railway station.
How?
My lord, on the basis of a license,
How can is the license forever?
no, my lord.
Then
It was renewed,
you fought a litigation in the Dimapur court which you lost it also.
My lord,
Have you challenged that order?
yes, it is understood.
What happened?
My lord, I am still awaiting instruction whether it has been restored, but I believe it is, but I do not have the confirmed information.
But if that you have challenged that order, then why are you
Not
separately
this,
moving this repetition?
There are two separate stalls, my lord. That is what the confusion the railway did. That relates
But
to.
madam, the fact is, how can you have your stall for your lifetime?
No, it's not
To me,
lifetime.
you're right.
Not lifetime, my lord. I was given a license when people would not even take license to run.
So does it give you a right for
Uh,
having it in perpetuity?
Not in perpetuity, but
Then-
some right, of course, my lord. Some right, of course.
No right.
My lord.
There's no right.
My
Absolutely no.
lord,
We dismissed, you withdraw with either of
my
nothing
lord,
doing.
neither, my lord, may kindly hear me, my lord.
Yes,
Now, what
tell
has
me.
hap-
Show me what is your right over that thing.
On the license continues, my lord.
How? Show me under what provision there can be a license for perpetuity.
It's not just like there are petrol pump licenses, my lord. There may be renewal and it may not be renewed. This is not a case of
No,
non-renewable.
in our railway station, they have policies
Yes.
by which they have a railway circular of 2017, they have a railway circular of 2010. All these are by which licenses are being issued.
Yes, yes.
Now, under such license, if you don't have it, then how can you get it for perpetuity?
I have it after the policy. I was renewed license
In 2017,
in 2018.
18, then there cannot be any further renewal.
My lord, it is not a question of non-renewal, my lord. What has
It is
happened,
not
my-
a question of no. You have no right over the railway land.
I'm not talking about my right over the land, my lord.
I'm not saying about railway land means railway station.
Exactly, my lord. I have no dispute with respect to that, my lord.
Show me that you're right.
My case is that on the basis of a license, I am running the stall. They have not cancelled my license. My license, while my license was in
Show me your license.
my lord, the time when I filed that last license, I have annexed my lord.
Oh, where?
2018 license is at page. I made a statement. I'll place it, my lord. It is annexed, my lord. I'll
Where?
place it. My friend is just finding out. Yes, the one. Page. While my friend is finding it, my lord, on the basis of the license I was running, that while the license was in.
Show me your license which gives you renewal. This is a letter written by NFA to Jayab Khan. Who is Jayab Khan?
Tahir Khan. Tahir Khan is the father of the
Tahir
petitioner.
Khan. No, this is being written to Jayab Khan.
My lord,
It's a biographical letter.
My lord, page 41, my lord, that there is a type copy. Page 41 and type copy is at page 40. My lord, I have no issue
Page
with
41, where?
Page 41.
Please arrange to realize so and so as per so and so from late Tayyib Ali Istol. for the month of June 2021. But where is your license?
And then this, my lord, there is one, my lord, which I have.
Understood, but where is your license?
This is the license.
No, this can't be a license. When you have enclosed out here various licenses at page 18. You don't have a license. Where is the question of granting you?
License, my lord. This license number, this license number 106, my lord, this is the original license which is being renewed from time to time. And this page 41, the license continues, my lord.
Absolutely no.
My lord, my lord, there is no dispute with respect to this.
Then
my
why
lord.
are you renewing it every time?
My lord, the fees has to be paid, my lord. It is not exactly, the fees has to be paid yearly, my lord.
Sorry.
My lord, there is no dispute with respect to that. My
Your
lord,
right to remain out there, you have asked for, got a status quo, an order by which the petitioner should be continue his thing.
asking for the right to remain there or not to remain there. My case is totally different.
What
my
is
lord,
your
which I am
case?
not able to project as
Yes,
now.
please project it.
My lord, I had this tea stall license, and later on, my lord, in the year about 1989, I requested for a pan stall. They allowed me, but they did not give me any space. When, my lord, initially the space that I was given in the old station, my lord, I had a very big space. But when this from meter gauge, when they converted to broad gauge, the space that was given to me was very small. And since we were continuing on the basis of licenses, my lord, we requested that we should be given a bigger space as it was before. They said that since we do not have space, you can use the space next to my already wherein I was holding the license. First, they gave me a Dala place, and then they gave me that space. Now, with respect to that space, there is a dispute for which I have not come before this honorable court. That is that for the pan stall, my lord. For the pan stall, when they asked me to move, my lord, I filed a suit, which suit whatever is the situation. I'm not just now not concerned with it, because here I am with a tea stall. So far as the tea stall is concerned, that is continuing. When the suit was dismissed, which was respect to the pan stall, they had a misconception, my lord, and they asked me to, because the suit was dismissed, that is what is their page 64, that you now vacate. Now we have come to this honorable court. We said that the suit notice to vacate was respect to the pan stall. We filed the suit with respect to the pan stall. The license number is also different. And if they can ask me to vacate, they can ask me to vacate from the pan stall premises, not from the food tea stall premises. That because of that misconception and because of this impugn order, I have come here. There is no problem with the fees. There is no problem with the license. No issue rather. No issue with respect to fees. No issue with respect to license. And they do not say that I do not have a license. And not only after this, after the writ petition also, I have been continuing to pay the license fee. With respect to the pan stall, I am not making any prayer, and I do not, I think it has been done, but I'm not very sure. So with respect to that, there is no issue. Now, because of that suit, they cannot issue this impugn order with respect to the tea stall wherein there has never been any issue raised. And since they have not filed the affidavit, therefore, whatever facts are, my lord, my facts has to be taken to be correct, my lord, so far.
Absolutely, I will take everything as gospel truth, but show me your license first.
My lord, this is the license and this is how it continues, my lord. If I am paying the fee, if they are accepting the fee, they will issue this fee. And if I have this receipt, my lord.
If you don't show me your license now, that you have a renewed license out here, then I can't grant you the relief.
My lord, so far as the license that I have.
If you don't have a license, the question of granting you the relief does not arise.
So far as
We'll take everything
my lord,
as a gospel truth.
my lord, I will just say, so if we go back to come to page number 18, my lord.
Let us see your prayer. See your prayer.
Prayer is for that, the order, my lord. Against
No,
the
no,
order.
read the prayer.
My lord,
Read in the nature of mandamus be not issued, directing the respondents to allot sufficient space to the petitioner for the tea stall for sale of puri, chapati, sweets, etc., as was held by the petitioner prior to the shifting of the petitioner to the present site in 1986, and allow him to run the tea stall for sale of so and or a writ in the be issued challenging the order dated so. How can this court grant you a relief unless you show me that there is an existing license?
My lord, this is what I say.
As on the, forget about other things.
once
Show me an existing license as on 2018.
Once a license is issued, my lord, once a license is issued, so far, my lord, I'm there from since 1950, my lord. Once the license is issued, my lord, on the basis of that license, they continue to take annual fee. But if they do not want my license to be continued, they will not accept and they will ask to vacate, my lord. And here the vacation order.
Where is your order or as on 2018, not today, as on 2018, there is a license renewal. Show me that.
My lord, the renewal fees, my lord.
Fees, payment of fees is different.
Renewal fee, my lord, once a license is issued by the
How do you say this pays 41 to be the renewal fees?
My lord, once the license is issued, my lord, unless there is, unless the license is terminated, the license continues, my lord.
No.
This is what it is, my lord.
Show me that.
My lord, so
Then in that regard, show me any railway circular to that effect.
my lord, so far as that is the practice, my lord. License number 106, my lord, at page
Or in the
20, my lord.
original license, it will be mentioned that it will continue for lifetime. The railway reserves the right to terminate the contract after giving notice in there, and it is decided as so and so. Shall deposit is so and so. The rate of the license charges here, you and there, you attend to the office on next 10 days or so and so. Where is that? Nothing to that effect. Every time it has been renewed. Every time there is a renewal license, renewal of vending license of one
My
stall.
lord, every time there is not a renewal, every time, annually we'll have to pay the fee, my lord. There's no question of renewal also, because it is not for a specified period.
Then why is at page 23 there is a renewal and at page 26 there is a renewal of the same stock? Why? If there is no renewal?
Page, my lord has said page.
I am vacating the order. You are not prepared. I'm
My lord,
vacating. No,
my lord,
sorry. You have not been able to show me anything.
My lord, this license that has been issued.
Show me
this
one
license
circular,
is
ma'am.
not
No,
for
madam.
a
Kindly show me one circular or your license that as on 2018 there was a license. Show me that document.
My lord, so I repeat the statement, my lord, that once the license is issued, unless it is terminated, the license continues, my lord. And if the license is terminated.
Show me that.
My lord.
What you are submitting, there has to be something on back on that.
My lord, a negative fact I cannot show, my lord. But this.
Are you saying that negative fact cannot be shown? It is not a question of negative fact. It is a question that a right accrues for renewal in perpetuity if it is not cancelled. Show me that.
My lord, let me so far as the railway.
Okay, I'm vacating the interim order.
My lord, interim order may not be vacated.
No.
There is no reason for vacation of the
I am
interim
giving you
order,
the reasons.
my lord.
There's a division bench to go there. I'm not going to do anything to that.
So far as the division bench judgment is concerned, I have a copy. They have challenged the policy. I have no issues with the policy. And after the policy, my lord, I have been continuing, my lord.
So
they challenge the policy. I'm not challenging the policy. I have no issues with the policy, my lord.
It categorically, those 2017 policy makes it categorically clear that there is no question of renewal.
Exactly, my lord. That is what I'm saying. There's no question of renewal, my lord. If I have paid the fee and they have accepted, my lord, my right continues. till it is terminated. My lord, those who challenge the policy, they did not want to pay the fees. They have been given a relief that you pay the fee and you may continue if subject to payment of fees and if the railways allow. In my case, I have not challenged the policy. I'm not challenging the fees also that they are charging, but I am paying the fee annually, even as on date till now, even I have paid till July 2024, my lord. After, because
Because this is on the basis of the court's order.
maybe, my lord.
Let us see as to whether they receive it if I vacate this order.
No, Lordship, we haven't received since 1/7/2014, Lordship. We
That
haven't received anything.
is incorrect, my lord. In page 12, here I have showed it that it
No,
is
that
paid.
doesn't show that it is a renewal fee. Anyways, unless there is a
It's
renewal
not a
license,
renewal
it is
fee,
not.
my lord. It's an annual fee. It's not a renewal fee, it's an annual fee. And my friend, he is stating without instructions, my lord. 2018, when I came before this honorable court, this is what we verified, whether he has paid the fees. If the fees is paid, my lord, that is which is annexed, and he is saying that they have not received since after 2014, my lord. I do not understand. On
What have you included? Show me that. Does it say that it is a renewal?
It is an annual fee, my lord.
Does it show that it is an annual? Show me.
That
Show me
annual
that
fee.
receipt which you are bringing out there at page 41 is an annual.
At page 41, my lord. At page 41, my lord. July 2017 to July 2018. Area license fee 628.10 into 13 months. 8,000 odd I have paid. Then area water charge, my lord, 23 rupees into 13 months I have paid. Area some charge which is at the page of 285 into 13 for 13 months I have paid.
And another thing, and not only that,
Hmm.
you have a particular clause out there in the railway circular that is of yes, Mr. B. Sharma. What is that clause which I have dealt with in that judgment which I have delivered, wherein it says that this particular period, if during the pendency of the license, it was by Mr. R. Dubey who has done that. If during the pendency of the license, the other or the person, the licensee expires, there is no fresh renewal. It will be only for the remaining period of the license. That is there in the clause 8, read with 27 and 20. No, here they have not included anything.
They'll continue till the license expires.
And for that, they are not entitled, that is as per the 2010.
10, 17.
Now, that is the 2010 policy. 2017, there is no renewal.
There is no renewal.
But here, what happened, this person concerned was in 2015 or 2016, there was a renewal being made for a period of 5 years. And thereafter, 2018 or 19, the period has ended. Now, he sought for renewal on the ground of clause 5 of 2010 policy. Clause 5.
Clause 10.
Yes, 5 of 10 policy, saying that as he is the year, so he has a right over that. This I heard that he does not stand in the shoes of the licensee because the legal representative does not stand in the shoes of the licensee. You were there.
Yes, it's
you were there in that.
And after the 2017 policy, my lord.
No, 2017 policy renewal is not there.
No, not at all permitted. Those licenses which have expired, my lord, they will have to go for fresh tender.
They have to go for fresh.
So far as, my lord.
And there is no renewal. The concept of renewal is foreign.
Exactly, my lord. Concept of renewal is foreign.
So what is your right? If you don't have a right, why should this court have an impediment?
My lord, when I came before this honorable court,
the court was considerate, unlike me. That is the only thing.
considerate, my lord. When I came before this honorable court, my lord, my annual fee was already paid for that year. And what they did, my lord, they wanted to remove me. There is not an issue of renewal or non-renewal also here. This is not the issue that is.
How
raised,
do you
my
have a
lord.
license?
But
The license are made on the basis of the circular. And if the circular does not permit renewal, what is your basis to have a right over the land?
my
Over
lord,
the
I'm not raising the issue of renewal, my lord.
What are you issuing?
I
You are
am
asking
saying,
for three reliefs.
my lord,
First, you are saying that 5/8/2018 is bad because it is on a wrong premise they have issued.
exactly, my
That is
lord.
one.
That is one.
On.
Yes.
But you are saying that to allot you additional space, which obviously cannot be given. And second, third, you are asking for that you should be allowed to continue with the tea stall. How can this court give you the second two? It is not possible in view of you have a particular area and that was the additional space given. So unless that judgment is not set aside in due course of law, that additional space is gone. One. The second is as regards your tea stall, that you should be allowed to continue. That can only be given if you have a license. But if you don't have a license, how can this court give? Yes, the third one is on a misconstruction of the order, for which this court will make a clarification to that effect. But how do you take care of number two?
My lord, so far as number 2 is concerned, in view of the 2017 policy, my lord, whatever the conditions, my lord, some bunch of people had also approached this honorable court, and whatever the relief.
All the petitions have been dismissed by me. The matter went to division bench. They have upheld it. The matter ends there.
My lord, it's all right. If there's a new policy,
The new policy is coming in 2028.
Policy, whatever has to proceed as per the new policy, it will proceed. I'm not on that, my lord. So far as the
But
first,
how can this court direct you to continue with the tea stall
my lord,
if you have no license?
my lord, so far as the prayer is concerned, the prayer has
Become
three prayers. My lord,
I've
has
seen it. Therefore,
yes,
the first
parts.
prayer is additional space, not possible. Number two
Not
is
possible, my lord. I won't say not possible.
not
because
possible
I was
unless
given
that
a
no,
bigger space,
no.
and that same license fee I was given for that
No,
space.
first
and
of
that
all,
fee is
whether
given
you
to
have
pay.
a right on the ground that in 1986 you shifted from there to the new place, for that you have a right will be dependent on the term of conditions.
Yes.
So whether it is there, you have to show it to me. If it is not there, this court cannot grant.
At the time when I came before this honorable court, and even I have instructions, my lord, they continue to pay the license fee. At the time when I came before this honorable court,
What do you want? Dismissal of the petition or the vacation of the interim order? What do you want? Either of it.
my lord,
I am giving you that option.
my lord, neither, my lord, I pray.
I don't have. I am not going to extend it.
My lord, no, I let the matter be disposed of also. I have no issues, my lord.
This one means dismissed.
But it may not be dismissed, my lord.
Dismissed.
At least that.
I only solace
that
I can
order-
give it to you that the order of 5/8/2018 was in respect of the pawn shop. That is the only solace I can give.
That is the only thing I want. The rest,
Only that.
Rest I do not want. Whether I should.
But this court
whether I
is,
should
but
not
this court
continue.
will categorically say that
As
this
per the
court is
policy-
not going to pass those orders in respect of the other two unless because no documents have been shown, thereby showing the petitioner's intent.
At the moment, my lord, I will
Then
not press
whatever
those,
you do,
I
you
will not press those prayers because there is a policy in the meantime, 2017. That 2017 policy, as pursuant to that, whatever needs to proceed, that may proceed, my lord. I have not even raised any issue with respect to that. My
No,
issue
you have
is
three
only
prayers.
that.
No, madam, you have three prayers. You have three.
Yes.
The three prayers which are there, I will deal with now.
At the moment, I will not press those first two prayers, my lord. But this prayer, my lord,
On
that
5/8.
on the misconception.
On 5/8. You are referring only to 5. You are only referring to 5/8.
15/8, my lord.
15/8.
Yes.
You are only referring to 5,
Yes,
15/8. The
15.
other twos you are not pressing.
At the moment, my lord, I leave it to them because I also understand my limitations, my lord.
Okay.
I am not saying that I should be allowed to continue, but on the misconception you are allowing, and later, my lord, I do not say I should be allowed, but this honorable court also may not say that I should be vacated. But whatever, as per the new policy that is the at present that is applicable, whatever needs to be done, they may take a call, my lord.
Okay. The instant
I'm
writ
grateful,
petition
my
has been filed by the petitioner, seeking the following reliefs. Roman 1. A direction be issued to the respondents to allot sufficient space to the petitioner for the tea stall for sale of puri, chapat, sweets, etc., as was held by the petitioner prior to shifting of the petitioner to the present site in the year 1986. Roman 2. A direction be issued to the respondents to allow the petitioner to continue to run the tea stall for sale of puri, chapati, sweets, etc. And Roman 3. A writ in the nature of certiorari be issued for setting aside and quashing the impugned instruction order issued by the inspector commercial Dimapur CMI DMB close to the OC RPF DMB and OC GRPS DMB dated 15/8/2018. The facts involved in the instant case, as could be discerned from the writ petition, is that early in 1950, the railway authorities had granted a vending permission to the petitioner's grandfather, one late Isha Khan. The license was issued initially for tea stall for sale of tea, puri, sweetmeat, chapati, etc. at Dimapur railway station. The said vending permission continued without any break. Subsequently, another vending permission for inverted comma Dalla DALLAH for selling pan, biri, cigarette at Dimapur railway station was also issued. It is the specific case of the petitioner that the petitioner grandfather had a vending permission for sale of tea, had two vending permissions, one for sale of tea, puri, sweetmeat, chapati, etc., and another for sale of pan, biri, cigarette, etc. It is claimed by the petitioner that the last renewal of the tea stall vending license was issued on 17/8/2018, and the petitioner had been paying all rents, charges, electricity bills, etc. till the filing of the writ petition. It is also relevant to take note of that the petitioner had to the instant writ petition have enclosed the renewal license permission to the tea stall and as annexure 1A, 1B, 1C, 1D, 1E, 1F, and 1G.
That page I could not show that it was not readable, my lord. There is a typed copy at page 36.
This court, upon perusal of the said enclosures, finds it that the enclosure and the annexure enclosed as the annexure 1A to 1E shows renewal of license number 106 for the period renewal of license number 106 granted to 15 on 15/9/2081 to Mohammad Tayyab Khan. And the last of such renewal was for the period from 1/4/2008 to 31/3/2009. Annexure 1F as well as Annexure 1Z are, however, not documents evidencing the renewal of the license number 106. Rather, Annexure 1F is a communication issued by the station superintendent NF Railway, Dimapur, intimating the various vending/catering contractors at Dimapur station to submit GST registration number as well as and Annexure 1G is a vending stall license fee. Of an amount of rupees 14,432. It further reveals from the records that in August 1999, the station superintendent Dimapur issued notice dated 4/8/1999 directing removal of the pawn shop of the petitioner within 24 hours. The father of the petitioner, late Tayyab Khan, filed a declaratory suit being DS number 7/1999, along with an application for injunction being Miss Case number 22/1999. It is further relevant that during the pendency of the said suit, the father of the petitioner expired and the father was substituted and the petitioner was substituted along with the other legal representatives of late Tayyab Khan. The said suit, however, was dismissed And the interim order and the injunction order which was passed was also vacated. On 16/6/2017, the learned counsel for the petitioner, however, submits that she has no knowledge about whether the said proceedings were revived or not. Even as on today. Be that as it may, on 15/8/2018, on the ground that the suit of the petitioner, filed by the petitioner, being DS number 7/99 was dismissed. The impugned order dated 15/8/2018 was issued by the Inspector Commercial Dimapur CMI/DMV to the OC/RPF/DMV and OC/ZRPS/DMV to remove both the tea shop and the pawn counter. And it is under such circumstances that petitioner has approached this court, seeking the reliefs as aforestated.
Lordship, the petitioner was never before the lower court, Lordship. It was the petitioner's father who was before the lower court.
No, the petitioner's father was there.
Yes,
He died.
Yes,
Then
Lordship.
the
And he was
substitution
never
application
substituted.
was filed.
No, it was substitution filed by the Tayyab Khan, the father.
Convert court has recorded it correctly. The father had filed the suit. The father passed away.
What is the petitioner's name?
Tahir Khan.
Tahir Khan.
Yes, Tahir Khan is there. In the matter of so Tahir Khan he was substituted. Tahir Khan died on 30/8/2008.
And
Can you see page 44?
Yes, sir. 42.
44.
44.
Wife of year. So and so, all counts of Tahir Khan. Did it? Tahir Khan filed the suit.
Yes, Lord.
And petitioner along with others was substituted.
correct. Correct. My lord, only that one, since there is already interruption, that this 64 order is DMB, not Dimapur, is DMB Lamding.
Which one?
My lord
15/8.
just dictated few sentences before my lord the interruption. My lord, I think I heard it. My lord mentioning the CMI TMB Lamding is not Dimapur. Sorry, it will be Lamding.
Inspector Commercial Dimapur.
Page 64. No, my. Page,
It is your prayer only. Everywhere you have said it to be Inspector Commercial Dimapur. And now you are changing everything.
no, right.
Okay, take your seat. All corrections individually. Yes. This court, by an order dated 28/9/2018, issued notice and further directed that the respondent to allow the petitioner to continue his tea stall in Dimapur railway station until further orders. The matter has been listed on various occasions. And on various occasions, and further, the railways have also sought for time but they have not till date filed the affidavit in opposition. even after a passage of more than 5 years have elapsed. Taking into account that there was no affidavit in opposition has been filed by the railway authorities, even after such a passage of time, this court have proceeded to dispose of the writ petition on merits, on merits on the basis of the materials placed before this court, on the basis of the merit records available before this court. This court at the outset submits, finds it relevant to take note of the submission of Mrs. B. Goyal, the learned counsel appearing on behalf of the petitioner, who submits that the petitioner is not pressing the reliefs as regards the reliefs as enumerated at Roman 1 and Roman 2 herein above. That is, the reliefs pertaining to direction to the respondents to allot sufficient space to the petitioner for tea stall for sale of puri, chapati, sweets, etc., as was held by the petitioner prior to shifting of the petitioner to the site in the year 1986, as well as for a direction to allow the petitioner to continue to run the tea stall for sale of puri, chapati, sweets, etc. The learned counsels for the petitioner submits that the petitioner here is only pressing as regards the order dated 15/8/2018, taking into account that the said order has been passed in respect of the two stalls which were permitted to the petitioner, which were being run by the petitioner. Although the decree so passed in DS 7/99 was in respect of 99?
1399.
Yes, 7.
Page 43, Your Lordship.
DS 7/99 was only in respect of the pawn shop of the pawn stall of the petitioner and not the tea stall. This court had duly, taking into account that the reliefs above mentioned, the two reliefs have been foregone by the petitioner in the instant proceeding, and the limited question available to this court is only in respect to the legality and validity of the order dated 15/8/2008. This court therefore finds it relevant to take note of the claim in title suit number, in declaratory suit number 7/1999, which have been enclosed as Annexure 7A to the writ petition. From a perusal of the claim in the said declaratory suit number 7/99, it would show that the said suit was against the order of the station superintendent, Dimapur railway station, dated 4/8/99, directing the plaintiff to suspend the sale of pan and to remove the pawn shop within 24 hours. Therefore, it is therefore the opinion of this court that the dismissal of the said suit, that is declaratory suit number 7/99, and the vacation of the injunction order passed in the said suit would only be relatable to the order dated 4/8/99, which was in relation to the pawn shop and not the tea stall. Accordingly, this court therefore On the no, in the backdrop of the above, if this court takes into account the order of 15/8/2018, it would be seen that there was a reference to it will be seen that the said order is not clear as regards as to whether the direction so issued by the by the inspector CMI/DMV was in respect to the pawn shop or the tea stall or to both. However, in the said order communication, the word has been mentioned as shops. Under such circumstances, taking into account the plaint in declaratory suit number 7/1999, it is observed that the said suit being a suit only in respect to the order dated 4/8/99, which related to the pawn shop and not the tea stall, the respondent authorities would be at liberty to take such course of action in terms with the order dated, communication dated 15/8/2018 only in respect to the pawn shop and not the tea stall. With the above, in that view of the matter, the instant writ petition therefore stands closed, it stands disposed of with the following observations, with the above observations and the directions. This court further makes an observation that this court have not dealt with the rights of the petitioner in respect to the tea stall of the petitioner, and it shall be within the ambit and discretion, within the scope and ambit of the railway administration to take a call on the tea stall as per its applicable circulars. The interim order so passed and no longer survives in view of the
It may merge with this file.
no merging.
Ultimately, it is merging file. Because it is open to them. I'm not asking for any relief. I understand.
You say merge, I say no merge, division benefit. Okay. I'll make it. Ms. B. Goyal, the learned counsel appearing on behalf of the petitioner, submit that the interim order therefore should merge with the instant writ petition, with the final order. It is the opinion of this court that as the petitioners have not been able to show any document showing their entitlement to carry on their vending license after 2009, such the interim order, the interim order cannot be allowed to be continued thereafter.
I have not prayed for this. I have not prayed that.
Don't make that therefore, no, and as such, the question of merger of the interim order to the present final judgment does not arise. You want that last line?
Actually, not actually, my lord. It is in my all respectful submission and with all.
This is the
humility-
case for
with all
division bench.
humility, my lord, when there is a final order passed, that interim order does not exist anymore. Whatever
That is
it
it.
is,
Shall therefore no longer survive.
that addition, my lord, that addition may call for another interpretation, but otherwise, that
You
interim
have to
order.
make it clear. Otherwise, what will happen? This interim order will be kept continue.
My lord, this will be
Madam, I have delivered. You want the first part or the second one? Tell me.
Only the first part, not the second part.
এখানে একটু আগে কৃষকের না লাগে the interim order dated so and so no longer survives in view of the disposal of the incident.
9.
I'm grateful, my lord.
Well, last case I thought that the time was taken for filing affidavit, my lord. Because the fact came, my lord, there is a RSA pending, my lord. In fact, when it lordship goes to paragraph number 18 and 19, there is on, they have stated that the RSA is pending, my lord. And it has last listed on 27 and 23, my lord. So, my lord, since the outcome of the RSA will depend upon the action taken by the DMDA, my lord. May be taken tag along with the RSA, my lord.
Who is appealing for respondent number 5?
Number 5. In the cause list, there is name is there, my lord.
Huh?
Learned State Council, Mr.
AC Sharma, respondent number 5.
was appearing. File.
What is the name? Who is appealing?
Mr. AC
AC
Sharma,
Sharma.
Learned State Council.
AD?
AC Sharma.
AC Sharma.
Yes.
Yes, what happened? Okay. None appears on behalf of the respondent number 5 on call. However, for the ends of justice, the matter can be adjourned to be listed after 6 weeks. It is made clear if the respondent number 5 is not represented on the next occasion, the court will dispose of the matter on the basis of without dispose in their absence.
My lord, I have received, I have been newly engaged in this matter. I have received this file, not yet, my lord.
Yes, where is that Mr. P. Sharma?
This matter may kindly be adjourned.
No. Whether they want to go ahead with the tender is the question. Where is Mr. P. Sharma? We'll have it after some time. Get hold of it. If he doesn't want, you are challenging a tender. If they don't want to go ahead with the tender, what is there? You should be happy. Isn't it? Have it after some time.
Please, your lordship. The matter may be adjourned today.
Why?
Engaged counsel is out of station due to medical treatment.
Okay. What is your name?
K. Buragohan.
The learned counsel appearing on behalf of the petitioner seeks for an accommodation. Yes, did you get the instructions? So, yes, what is the status of this land? 161, 163, and 63?
The tag number 62, pata number 35, lordship. That land was not acquired, lordship.
That's the land of the petitioner.
Lord.
Have not been acquired. But petitioner has land in all this, 161, 63, and 62. Have you acquired any of them?
No, the grievance is regarding this top of the land, lord.
Huh? Beta half kata followed by that number 2.
And pata number 30.
Can the railway department acquire land?
No.
If we require land, we'll send a request to the government of Assam, then they will acquire on our behalf.
So we hold it that the
narration,
land has not been acquired. And it still continues in the name of the petitioner. We make it clear. Petitioner will be happy. You wanted compensation if it is a case of acquisition. They said that the land has not been acquired. So we make it clear that the land of the petitioner has not been acquired, for which petitioner shall have due right over that.
And it's total paragraph 5 lordship, paragraph comment, last sentence lordship. However, this office has no record regarding acquisition of land for the railway department.
Railway doesn't acquire land on its own.
Unless you acquire, can you say that?
No.
I've asked you as to whether you have acquired this land or not. What is this type of instruction?
And even the notice, my lord, of acquisition was issued by the government of Assam, page 11. Even notice of acquisition was issued by the government of Assam, not the railway, page 11, next to it. That is the notice. So, there's no role of the railway. The purpose was totally different, not for any purpose the railway. So, for extending some road.
Then why did you mention this notice? What is this note? What do they have to say about this note? Annexure B. Regarding the order issued by the government on 23/2000 Iman for the purpose of extension, any record could not be traced out in this appeal date. What is this? The simple thing is, you will be having it in your records as to whether the land has been acquired or not. And that too when it is being done at the instance of the SDC or the DC's Jorhat. And how can the DC say that we have no instructions to that effect?
Finally, acquisition did not take place.
Put it on affidavit. Exactly the same, not this thing. As to whether land 62 has been, dark number 62 have been acquired or not. By way of an affidavit. Because on the basis thereof, I will hold. Tomorrow, on this basis, tomorrow, you may not be the government advocate. And somebody may file a case against. It can't be done on this. Pursuant to the order dated 8/11/2023, Mr. N. Goswami, the learned counsel appearing on behalf of the respondent state submits that he had received a communication issued by the additional deputy commissioner L.A. Jorhat, wherein it has been mentioned that as regards the communication dated 23/1996, issued by the government of Assam by number RLA 38/96/2-3, which was for the purpose of extension of the Moriani Jorhat Road, no record could be traced out. It has also been mentioned in the said instructions that the land measuring 3 Katha 10 lechas covered by dark number 62 of Pata number 35, situated at Napomua Sodang Gaon under Katoni Moza of Moriani Revenue Circle in Jorhat district, have not been acquired for the purpose of acquisition of land for Jorhat Moriani Mukuksong Road of State Highway -31 Jorhat. It has, however, been mentioned that the office has no records regarding acquisition of land for the railway department. Mr. B. Sharma, appearing on behalf of the railway authority, submits that the railway authority does not acquire the land. The NF Railway Authority does not acquire the land on its own, but acquires land through the State Revenue Authority. And as such, the question of the respondent deputy commissioner having no record does not arise. So, taking into account the above, this court directs the additional deputy commissioner L.A. Jorhat to file an affidavit before this court, categorically taking a stand as to whether dark number 62 of Patna number 35 of village Nav Pomua Sodang under Moza Katoni in the district of Jorhat was acquired by the revenue authority at any point of time. The said authority, further to that, the circle officer of Jorhat Revenue Circle shall also enclose to the said affidavit, shall also submit a report as to in whose name the said land at present stands, and the said report shall be a part of the additional affidavit to be filed by the additional District Commissioner LA Turhat as directed herein above. List the matter again on January. Type it already. Okay. On 22nd of January 2008. Well, yes. Your petitioner in person?
Yes, Lordship.
Yes, what has happened?
Lordship,
Your name is?
D. Bormon, Lordship.
Huh?
D. Bormon.
D. Bormon.
Yes, Lordship.
Just 1 minute, huh? D. Bormon. Now tell me, what is your case?
Lordship, I have
Inaction of the Guwahati man to demolish the illegal construction even after issuance of notice and like. Who is paying for these Rubin Boro and all these things?
I am for the respondent number 4.
Private respondent.
Yes.
Yes. Why haven't you demolished?
Lordship, basically, it's not a case of unauthorized construction, but we have some land dispute now.
And already a
No,
civil
Lordship.
suit is pending in civil court.
Huh?
Same subject matter.
Lordship, both in the title suit, Lordship, I filed a title suit for Lordship for ejectment on the tenant, Lordship. And
Is a tenant?
Ejectment on tenant, Lordship.
These respondents are tenants.
Respondent number 4 is the land giver, Lordship, and respondent number 5 and 5 to 10 are the respective tenants of the lands, Lordship.
Of your?
Yes, Lordship.
Your tenant or the respondent number 4's tenant?
My tenant, Lordship.
So who has constructed?
Respondent number 4, Lordship.
4. And where is your suit?
The title suit copy, Lordship, in the executive in opposition, filed by the respondent number 4, Lordship.
Huh?
In the annexure, page number 56, Lordship.
You have filed.
Yes, Lordship. And the payer person is at page number 67. 66, 67, Lord.
So have you got an injunction of the?
No, Lordship. Till today, they did not file in the written objection of the injunction petition, Lordship.
Very well. And what has happened to your injunction? No injunction. Pending where?
Civil Judge 1, Lordship.
Huh?
Civil Judge 1.
Very well. But Mr. Petitioner in person, this is the same relief he was being sought for?
Lordship, direct petition have filed earlier, Lordship.
Now, when there is a dispute as regards title, because you are asking for your right title and
yes, Lordship.
Now, when there is a dispute as regards your title, and when the GMD authority say that when there is a dispute regarding the title, where is the question of directive demolished? How do you take care of that?
Lordship,
You have challenged you say you are a petitioner in person. You are adverse with law, seeing your court. When do you file a suit for right title and interest?
2008 report.
You file a suit
Yes, Lordship.
for right title in place when, because of some actions of somebody, clouds your title. That is why you seek your declaration of right title and isn't it?
Yes, Lord.
So on the basis of that, whether respondent number 4 is entitled to remain in your land or not
Lordship.
is a question to be decided by the civil court.
Yes, Lord.
Now, when the civil court is in session of the matter, can Mr. Peanut step in and say, no, with this one. Tomorrow they will file a writ petition. Look here, when the suit is pending, what business does Mr. Peanut have?
Lordship, after filing
The best option would have been to get an injunction for any construction because you are already asking for the relief of demolition. So that is your final relief. Now, in your final relief, now you are asking, they have categorically made a stand that you look here. The dispute is not on the question of unauthorized construction. I mean, violation of the bylaws or construction which have been made illegally. It is a case of where there's a dispute between him and you for the purpose of who gets the relief, who is owner of the land.
No, Lordship, actually, before issuing the demolition notice, the GMD authority have already filed a notice to submit the NOC of the approved drawing for the construction area, Lordship. But he failed to comply of the request of the GMD, Lordship. Thereafter,
What NOC?
whether he had got any NOC, Lordship, for construction, for the illegal construction, Lordship. Annexure 8 and 9 of the petition, Lordship.
Yes, Mr. Naik, he has a NOC. Do you have a NOC?
That instruction.
Madam, you have phone number 4.
Yes.
You have a NOC?
Yes, sir.
Show me that.
Lordship, kindly peruse the Annexure 8 and 9, page number 43 and 45.
Of your petition?
Notice issued by the GMD authority, respondent number 4. Lordship, page number 43.
Certified copy of the notices issued, number, Iman are included. The supply of the notice of will. Yes, where's your boundary wall? No NOC.
NOC is not here.
You don't have. Huh? What do you do?
Lordship,
If you don't have a NOC, you allow it.
Definitely not. Definitely no.
Huh?
Definitely not.
So then what action you are required to take? Forget about what is a dispute between them. But without the NOC, can you allow if any construction is made? Are you saying that we would not take any action?
But that is not there, not. But issue is not. They are waiting for the outcome of the civil court.
Who?
And GMD.
No. Understood. That is a dispute between him and him. And are you saying when a person files a suit claiming right title and interest against somebody, and the other side could be entitled to construct a multi-story building without taking a GMDA on the ground, and the GMDA will shut its eyes because there is a suit pending? I would have understood that if there is a case.
Our understanding, subject to what it is. Our understanding was that if the land belongs to him, as he is claiming God, and if some unauthorized construction is there, then basically it's his responsibility to remove that property.
No.
If he is claiming the plot to be his own or not.
But why have you issued the notice to him? Who has constructed this? Madam, The wall who has constructed.
I have got that.
So she admits he has constructed. Are you going to allow that?
Lordship, next certain they have already issued a demolition notice, Lordship.
Are you going to allow that? Are we to understand that the GMC, if there is a suit out there, irrespective of whatever violation they do, they can even construct a 100-story building without the permission?
That is no, Lord. But
Tell
we
me.
are just because of the.
You can't
petition
wait.
this case.
Here is an infraction without the NOC. If he has applied for the NOC, it's okay. Otherwise, what is going to happen because of this? Your NOC is a very vital document for him. And you don't grant an NOC unless there is a land document. Would you grant the NOC without a land document? No. And that is why he has not got the NOC.
Lordship, in that case, Lordship, in the next week, Lordship, I will place instruction as regard the status of this one.
Because as she doesn't have a NOC, and she says that she has constructed without a NOC, what the GMD is.
Lordship.
Upon hearing the learned counsels for the parties, this court had put a specific query upon Miss, what's your name? D. Borman, appearing on behalf of the private respondents, and more particularly, the respondent number 4, as to whether she has a NOC for construction of the boundary wall. And as to whether the boundary wall was at all constructed by the respondent number 4. The learned counsel duly submitted that the boundary wall was duly constructed by the respondent number 4. And the respondent number 4 have not obtained the NOC as is required from either the GMC or the GMDA. Under such circumstances, this court had put a specific query upon Mr. P. Nayak, the learned counsel appearing on behalf of GMDA. GMDA or GMC?
GMD.
GMDA.
GMD. Notice query issued by
GMD. As to whether the GMDA, on account of a title dispute between the petitioner as well as the respondent number and the private respondent, should close its eyes, would do anything if there is an infraction to the provisions of the Guwahati Metropolitan Development Authority Act 1985 and its building bylaws. List the matter again on 19th of December 2023 for further, on which date Mr. P. Nayak shall apprise this court as to what is the stand of the GMD. The said stand of the petitioner of the GMDA be brought on record by filing an affidavit by 15th of December. 13.
My pleasure, Lord. In connection with this case, we have stated that it is in opposition filed by the respondent number 2. So I may be allowed 2 weeks time to file it.
What is your instruction, Mr. Gowe?
Lordship, he is actually the petitioner in this matter, Lordship. Is subletting the flat in question.
Violating the?
Subletting the flat in question.
Flat?
Yes, Lordship, housing board premises, Lordship.
And?
She subletting since long ago. She has not been residing in this flat. Earlier, one person named Rituparna Deka, who is illegally occupied the flat, for the advice of this instant petition, Lordship. Now just before one day, Lordship dated.
Is there a stay?
Yes, Lordship, there is a stay order.
And you are still, who is occupying there?
Lordship, still, it's as per our record, 23/11/2023, 2023, the officers of the Assam State Housing Board went to this flat in question and found that one Sri Muhammad Safiqul Islam have been residing in that flat.
Who is he?
Lordship, as per our instruction, Lordship, petitioner's elder brother, he was resided there.
Who?
Not
Petitioner's elder brother.
Yes, Lordship, as per our instruction.
He is Safiqul Islam.
No, Lordship. Safiqul Islam not
Lakshmi Nandan Sharma's elder brother
No,
is
no.
Safiqul Islam.
Safiqul Islam not his brother, Lordship. As per our instruction, Lordship. So, by this affidavit, they have raised some new issues, Lordship. We have
He'll have it tomorrow.
I'm ready.
You ask the OC of which place? Garsuk police station to go and visit and submit instruction of as to who is residing there today. Huh? I'll sign the order now. Who is residing out there? If it is there, not only cost, we'll take further cost of it.
But may I put it on record?
You do one. Pursuant to the order passed by this court on 15/11/2023, the respondent number 2 has filed the affidavit. You have filed the
Lordship.
On
Yesterday.
yesterday. Filed it. Huh? Yes. During the course of the hearing, Mr. T.R. Gogoi, the learned standing counsel for the respondent number 2, had submitted that in respect to the flat bearing number, what is the number?
EWS building number 1, unit 17.
EWS building
number
L, unit number 17 under rental housing scheme at Bhetapara, Guwahati. Which was allotted to the petitioner.
In 2006.
Is under the occupation of one
earlier it was Ritupon Deka, now Safiqul Islam.
One Safiqul Islam.
Lord.
And as such, the petitioner is not entitled to remain in possession and is not entitled to the relief as has been sought for. He submits that. When did you go for it there? Verification
23/11/2020.
He submits that who went?
Mr. Pinak Oza, upper class UDL.
He submits that one Pinak Oza, one Sri Pinak Oza, who is an upper class
assistant.
Upper class?
UD, short form UD, upper class assistant.
Upper UD, upper. Of the respondent number 2 had visited the said flat and found that said Islam, Safiqul Islam, was residing there with his family.
With his
family. This court fixes the matter tomorrow at 10:15. This court further directs the officer in charge of Garsuk police station to carry out to either by himself or through an officer of his police station visit the said flat today and submit a report before this court as to who is presently residing in the said flat. This court therefore requested Mr. N. Goswami, the learned government advocate, to instruct the officer in charge of Garsuk police station to do the needful as directed. A copy of the order be served upon Mr. N. Goswami during the course of the day. for necessary compliance. Mr. N. Goswami shall place before this court tomorrow at 10:15 the said report.
Lord, I am not confirmed whether it is under the Gorsu police station or district.
Which will be? Bhetapara will be got to. Hatigaon. Oh, Hatigaon?
Hatigaon. Yes, Hatigaon.
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 We get what is there.
Math.
So mighty, buddy. Yes, madam.
His Lordship, I apologize that we could find our file later on subsequently because my junior has mentioned for that and Honorable Court has passed an order. He informed me that.
No, it's okay. That order, I have not find it or anything has happened because it was a mistake of the court master to call the matter when I said that the matter would be taken up at 2. But anyway, tell me, what is your case?
Lordship, so subsequently I got my file, so we could search it out our file. So I need some time just to go through and if you Lordship.
No. Anyway, let's see the relief. You have looked into the matter. I have also looked into the matter
Yes,
for the first time. I have not seen the matter earlier. What is the relief you are asking for?
Really rare.
Registration of FIR, Lordship.
So if a FIR is not registered, why should this court exercise
I
jurisdiction?
can understand. I can go under the CF50 here.
Number 2. Number 2 and 3 hinges on the same thing, to direct the compensation.
Yes.
Now, to direct the compensation, this court has to find out that there is a negligence.
Yes.
And the question of negligence cannot be decided in these proceedings.
Yes.
So wouldn't it be appropriate on your part to file a civil suit and as well as move under that?
Yes.
So that is it.
Yes.
In fact, that was the order which I said that in view of Sakira Basu versus then, you would be given the liberty to approach the court under 156(3).
Yes.
And as regards the other 2,
Yes, Lord.
liberty is given to you for the purpose of filing a litigation in the competent court. They have to prove negligence. To get compensation, they have to prove negligence.
Yes.
The instant writ petition has been filed by the petitioner. By the petitioner. Alleging that the North Guwahati police station have not registered the FIR so submitted by the petitioner against the security personnel of the IIT Guwahati, which led to the death of one Kishok Burua. The petitioners have also sought for a compensation of an amount of rupees 50 lakhs to be paid to the family of late Kishok Burua, and also have sought for a direction to the IITG Guwahati to review the security protocols and direct the security personnel who are properly trained to handle situations of crisis in future. It reveals from the records that the respondent number 2 had filed an affidavit in opposition denying the contents of the writ petition, as well as also stating inter alia that there has been no negligence on the part of the officials of the the security personnel of the respondent number 2. This court, after giving an anxious consideration to the matter and the submissions made by the learned counsels for the party, is of the opinion that the reliefs which have been sought for in the instant writ petition cannot be granted for the following reasons. Number 1, the relief as regards directing the North Guwahati police station to register the FIR cannot be granted in view of the fact that the petitioner has an appropriate and efficacious remedy available under section 156(3) of the Code of Criminal Procedure 1973. And in view of also the law laid down by the by the Supreme Court in the case of Takira Basu versus state of so and so, reported in so and so. Number 2, the reliefs as regards reviewing of a security protocols of the IIT Guwahati and for a direction that the security personnel should be properly trained to handle situations of crisis in future, as well as a direction for payment of compensation on account of negligence, in the opinion of this court, cannot be granted, as the said would entail adjudication of disputed questions of facts as to whether there was any negligence on the part of the security personnel could lead to the death of late Kishore Borua. The petitioners herein would be well advised, therefore, to approach the appropriate civil courts seeking compensation and for appropriate relief. Accordingly, the writ petition is therefore not entertained, for which the instant writ petition stands dismissed. However, the dismissal of the instant writ petition shall not preclude or prejudice the petitioner to avail the remedies as aforementioned.
State of AP, Lord.
State of UP.
UP?
Yeah.
State of UP, my lord.
State of
Give you a name.
Obliged.
Lordship, here we will definitely go for recalling the tender, but there is some official problem, Lordship. Locating the file, Lordship. We'll need some time, Lordship. We'll
Why?
go.
Every time I've been giving you so much
No,
time.
Lordship, actually it was 2018 matter. Director of Fishery. Actually, this matter was pending since so many years. It was not being located or not being listed also. So
No, these are case of fish feed. Now, this fish feed, the rate at which you have quoted, the estimate which you had, as of now, cannot be given to him or her because of the fact that the amount has already gone up.
Again,
this was of the year 2018. We are concerned in 2023, that too in the fag end. Then what remains? That is why I've been asking you as to whether the fishery department is still, who is going to come with that estimate? Are you going to supply at that estimate? No, nobody is going to supply. I'm asking you the simple thing.
Lordship, they are now, they actually locating the file needs some time, Lordship, 4-5 days, Lordship. 4-5
These
days.
4-5 days is going on from since every time. 4-5
Lordship,
days.
actually, the file is, the stay was operating since 2018 and they have, just now it was being listed, Lordship.
Mr. Sharma, on 8/11 this matter came.
Yes.
I
yes,
told
yes,
you.
I asked
Then I
them,
fixed the matter again as
Actually,
per your request on 10/11.
I'm very.
Then you said 4-5 days. Then I fixed it
Lordship,
again on
last
15/11. And then again you said furthermore.
Lordship, it is,
Then
I'm new to this department, Lordship. Like, give me 1 week time.
So they
I
are
will,
not
I will, I
hearing
will,
you.
I will procure the instruction, Lordship. In all that, just 1 week time, Lordship. I've already, they are going to withdraw it, but written instruction is needed, Lordship. That's the thing, Lordship.
The instruction which was sought for by this court on 10/11/2023 from Mr. P. Sharma, the Standing Counsel of the Fisheries Department, is still awaited, for which the matter stands adjourned to be listed after 6 weeks. Interim order passed earlier shall continue till the disposal of the writ petition.
Obliged.
Yes.
Yes.
Are you interested with the tender?
Yes, Lordship, my instruction is they are not interested in the tender because due to influx of time, the validity of the price bid is also over. And Lordship, the fund allocated to the particular tender is also Lordship ended. Fund allocation that was ended in the earlier Lordship. That was my instruction. Therefore, Lordship, they are not going to hold it the tender process.
So can we record it on your basis of your verbal instruction?
Yes.
Or you have got it?
Yes.
So nothing. We'll decide some other day. Mr.
Yes, to the Lordship.
Eh?
Sutradhar.
As Sutradhar, the learned counsel appearing on behalf of the Indian Institute of Technology, Guwahati, had submitted an instruction issued by Mr. B. Bora. Who is he?
Lordship, they are the committee members.
By the officials of the Indian Institute of Technology, Guwahati, stating that the tender which have been put to challenge has already become invalid and the validity of the price bid is also over. It was also mentioned that the technical specifications and the requisite items to be opted against the uploaded NIQ have also become obsolete as it is 5 years old. Further to that, the fund approved allocated against the indented item was for a specific financial year 2018-19 and the same ended under its standard terms. The said instruction is kept on record and marked with the letter X. In the view of the above, as the tender in question, which have been put to the tender in question, of which the clauses therein have been put to challenge, is no longer going to be acted upon by the respondent, Indian Institute of Technology, Guwahati. The instant writ petition has become infructuous, for which the same stands closed. It is, however, mentioned that the instant writ petition, having been closed as infructuous, shall not act as a res judicator against the petitioner to assail similar terms if necessary on a future date.
Like,
yeah.
Obliged. We keep it.
14.
Repetition. For
Yes, what is this?
for missing of the son of the petitioner, your lordship. For the son missing of the petitioner, your lordship.
Son?
Petitioner son has been missing, your lordship, 2018, your lordship. He has filed 2 FIRs, your lordship. But since then, no investigation has been taken place, your lordship, and the son still missing, your lordship. And as such, the petitioner filed his petition to transfer from the state police to the CBI so that proper investigation can be taken.
Yes, CBI.
Lordship, let a status report be called for, Lordship. Let a status report be called for. What is the stage of investigation, Lordship?
Last date, your lordship,
Who is doing the investigation?
By state police, Lordship. Mr. Gogoi is there, Lordship.
Who?
Additional PP Gogoi. He's there. Gogoi.
State police is who? And who is paying for the private respondent? You can appear on behalf of all these things. This court, upon hearing the learned counsels of the party, is of the opinion that before taking further steps as to whether, before considering as to whether the investigation pertaining to Jalukbari PS case number 1768/2018 is required to be handed over to from the state police to the Central Bureau of Investigation. The status report in respect of Jalukbari PS case number, there are 2 cases.
Yes, sir.
As to whether the investigation in respect of Jalukbari PS case number 1510 of 2018 and Jalukbari PS case number 1768 of 2018 are required to be handed over from the state police to the Central Bureau of Investigation, finds it relevant to obtain, to peruse as to what is the present status of the said investigation. Accordingly, list the matter again on 20/12/2023, on which date the Mr. B. Gogoi, appearing on behalf of the respondent's state authorities, and more particularly the officer in charge of the Jalukbari police station, shall place before this court the status report. The registry shall show the name of Mr. B. Gogoi appearing on behalf of the respondent state.
That may be 2020.
2012.
Lordship has already fixed.
Mr. I have given this thing, huh? You have got that order? They will give it to you. Forward it. Or ask Mr. B. Gogoi to do it. He is also from the PP. So immediately his things may be asked. 15.
I have got the affidavit up there. I will file my reply within 7 days.
Mr. Ashish Sekia, the learned counsel appearing on behalf of the petitioner, submit that the said affidavit in reply which was directed to be filed could not be filed due to certain difficulties. Accordingly, list the matter after 6 weeks. In the meantime, the affidavit in reply be filed by the
Apply.
Yes, who is appearing?
Mr. Pankaj Singh is appearing on these cases.
Who?
Pankaj Singh, Advocate Pankaj Singh.
Yes, where is he?
And I'm for the defendant. Respondent number 3, we have filed our objection yesterday. Let us not come on record here. Moreover, the copy of the writ petition has also been
Is the petitioner
Yes, what is it? What is your case?
Lordship,
Who is appearing for the respondent? You are Mr.
Respondent
Ganguly.
number 3. I'm on behalf of Mr. Ganguly, Lord.
What is it?
So we have filed our objection in the IA, Lord. That is
Lordship,
not
in
common
that case,
record.
we have,
But moreover, we have not received a copy of the writ petition, Lord.
What?
Yes, Lord. We have made
PNB is not made a party till today in the writ petition.
Huh?
PNB respondent number 3 objection that has been filed on behalf of PNB. I have a copy of that. So PNB, earlier it was United Bank of India. Now it has been taken over by PNB. So PNB is not a party in the writ petition actually till today.
So,
Copy as LS, that copy was not served. So that
you must be knowing na, that United Bank of India merged with PNB, and now all assets and liabilities of PNB has been taken over. United has been taken over by PNB.
Yes, sir.
So, do I need to tell you any further?
So,
Why you are not serving a copy?
actually, no one was appearing as per record. I didn't find anyone in any order. So
Now you know, when
yeah.
they file their objection, they have filed a petition, everything.
Then I will start
Then,
today itself.
then why you not serving a copy? And what is the petition asking for?
Actually, here the second RC 4/11/2019 and the last order, your lordship kindly see Peru annexure E and D. These two, one order of the DRT and subsequently an attachment order that are under challenge in the writ petition, lordship.
Why?
As per the pleading, these are not done as per process of Mensa.
As per?
As per the process of law, as pleaded in the writ petition.
No, whoever, what is pleaded out there, what is you? You are a lawyer, tell me. Or he wants to say anything. You want to say anything?
Because I have engaged one morning was attending over here, but right now he's not going in the beach.
Then? The learned counsel appearing on behalf of the respondent number 3 submits that the petitioner have not served a copy of the writ petition. The counsel appearing on behalf of the petitioner is directed to serve a copy of the writ petition during the course of the day to the respondent number 3. List the matter again after 2 weeks.
Lordship, it's possible that date can be fixed.
Why?
Advocate engaged already.
He need not come. He can very well have it through VC if he wants. I'm not asking anybody nowadays to come out here. You can also stay at home and do your math. 2 weeks or 4 weeks.
17.
Yes.
My lord, there is a public complaint, my lord, which lordship may see at page 36. And after that, my lord, my factory, my lord, is closed down, my lord. 36 is the public complaint, my lord. There are two factories, my lord. One is closed down and one is still operating in the same place.
What is this? You have some factory.
Factory, my lord, two factories.
Then?
Two factory was operating, but it's earlier it was running from 1960. So, my lord, by the lapse of time, my lord, there are lots of residential houses in and around the soap factory. So there was a public complaint, and there's another soap factory, my lord, running, but that has not been closed down. Now, after that, my lord, the inspection was conducted by the pollution and the DC, my lord. Lordship may see page 38, my lord. So I've been asked to comply with certain recommendation. That inspection report is at page 39. Lordship may see that page 39 recommendation, my lord. Then Lordship may, before that, Lordship may say inspection report, clause 10, Lordship may see. there is another detergent soap factory unit, namely Mrs.
I'm not concerned. First of all, do you satisfy these?
My lord, I have satisfied, my lord, most of the part.
Most of the part also, why should we?
No,
Now, are you still running?
no, I'm not running, but that
Very
is
well, don't
by the
run.
DC, my lord.
If you don't satisfy the conditions, what to do with that? The fact that if there is any pollution out there that needs to be, that cannot be countenanced,
Satisfied, my lord. Now,
can't help you. And not to act on public complaint. Where will the public go then? They will all come to the High Court. I'm asking you, if this is the relief you are seeking for.
My lord, the lordship may see that interim order, my lord, that page, my lord, it's passed by DC. Actually, it should be passed by the municipal board, my lord. Page 55, my lord. This is the order, my lord. The DC has passed by each, after the municipal act, it should be the board, my lord, municipal board should close down. But
Then you're challenging this.
yes,
No stay.
no.
You're not running.
In the meantime, Corona was there, my lord. So, lordship may, but what I suggest, my lord, I will file a representation before the authority concerned, before the board. Let the board take a decision, my lord.
Who has asked you not to?
No, but under the circumstances.
No, you do. But don't try that this court should act as the post court.
No, that's correct, my lord. I'm not saying that.
I am not going to deliver your request that you will submit a representation and then he will consider. No. I won't allow the respondents to consider unless I find that you have a legitimate expectation. If we are not complying with the directions or there is a violation, and who is paying for the pollution? Yes. What are you doing? There's a violation, air prevention. What you are doing?
Actually, I'm appearing on behalf of S. Burwa. As per my direction, they are not obtaining the consent of the pollution control board for running this.
Have you taken the NOC?
No,
Have you taken the NOC?
No, I've taken NOC, my lord. Last 2 years, I could not, because the factory is closed down by the DC file. So there was, I have applied for, my lord, but the license has not been granted. Pollution license.
So without the operating license, you cannot.
No, yes, correct, my lord, because
Now, have you sought in your petition for a direction to the area to give you the pollution control license?
yes, my lord.
Where is that?
Lordship may say player D, my lord. Page 20.
Trade license, that is a different thing.
License, then
These are nothing to do with
operate-
as regards the NOC for to operate as per the pollution control board.
Yes, and consent to operate a letter policy certificate to the petitioner to run its factory.
So, why is this vague? And where? Pollution certificate to the petitioner to run its top step. Now, what is your stand? Why you have not issued? Have you applied?
They have applied after receiving the notice from the PCPA. They have
Then what happened? What are you doing?
My
You're
lord,
sleeping over
already
it.
that was the deputy commissioner already closed down the.
Forget about deputy commissioner. That's another thing. But see, the deputy commissioner will take any action provided that is in violation to the Pollution Environment Act.
Yes, sir.
Now, Environment Act has various rules or acts, which are the Air Pollution Act, Water Prevention Act, and all whatnot. Now, these are within the domain of the Pollution Control Board. And what is the Pollution Control Board doing? Have you filed affidavit?
Yes, your lordship.
What is your stand?
Sorry, your lordship.
What is your stand?
Pilot, we have just replied in their our affidavit that they're running the soap factory without the consent of the PCBA, and they're applying for the consent after receiving the notice from the PCBA department.
Now,
But before
okay.
before that only they have not applied.
Anyway, you see, if there is a health hazard, the deputy commissioner has no the expertise to find out. You have the environmental engineers, you have this environment, all these people. You have to look into it. Have you looked into it?
My Kali answered them better for that today.
Why?
Actually, I'm not at all aware of this case.
Okay. We
Detail,
adjourn it
that's why.
as per your wish. How much? 1 year? You pay, how much is your loss every month, every year? Let the pollution control board pay him the loss which he's facing every day. You're going to pay. Then, don't you think the matter is urgent? Somebody's business is at
Yes,
stake.
Your Lordship, but due to some personal problem, he is unable, concerned advocate is unable to appear before this court.
So we impose it
for
to the
another
upon,
day.
we impose the cost upon the advocate. Mr. Roy, I think the only way the relief can be granted to you is directing the pollution control board to make necessary checks and find out as to whether you have it within the purview of those acts.
Yes.
And if you have, then to give the NOC to you.
Yes.
And on the basis of which the order which have been impugned will be nullified if it is the pollution NOC is given.
Only cases
So unless you have the NOC, you cannot.
I cannot find. Correct,
So
right.
you are to get the NOC from those people.
Right. That for
So
only
that
thing
is the only way
yes,
out. Although you have asked for various relief, but the relief has to be molded in this manner,
Right, sir.
by which you to be given an NOC after the pollution looks into as to whether you comply. And once you get, then the DC or the district magistrate has no business.
Only thing is, but the DC has no authority manner to cancel my license.
Understood. But then also, as of now, can this court allow you to run?
Right, man. If Lordship says that the pollution.
I think that is the way by molding the relief which can be done.
Yes, ma'am.
Anyways, can't help you. You take your instructions on this. You make a check as regards the petitioner, what is to be done and not. Find out as to whether it meets the norms.
Yes.
He has filed an application.
Yes, Your Lordship.
You inform this court what have you done as regards his application for the next. Then we'll have, I think, on the basis of which we'll pass. Miss, what's your name?
D. Datta, appearing on behalf of.
No appearing on. So and so appearing on behalf of the Pollution Control Board submits that as per her instruction, the petitioner was running the factory without the required consent from the Pollution Control Board, for which the Pollution Control Board had issued notice to the petition. It is only pursuant to the issuance of the notice that the petitioners have submitted application seeking consent from the Pollution Control Board. However, she submits that she has no instruction as to what has happened to those applications filed by the petition. So, under such circumstances, this court therefore fixed the matter again on January.
Or when I December end before vacation.
You want to have it this year? Okay. On 21st of December 2023, on which date the Pollution Council appearing on behalf of the Pollution Control Board shall apprise this court as to what steps have been taken pursuant to the application filed by the petitioner seeking consent. But madam, you find out this is what I think this would be the proper order by which, if you grant the license or say that he is okay with it and give the consent, then obviously the district magistrate has no business.
May it please your lordship.
Yes, madam.
Yes, right.
As to whether the petitioner would be entitled to the land as per the order dated 23/2017.
No.
I've asked you to file an affidavit.
Yes, Lordship. Instruction received.
What is it?
No.
Continue. This court have duly taken note of the instructions which were placed by Mrs. S. Borua, the learned junior government advocate, pursuant to the orders passed by this court on 22/9/2023. From the said instructions, it reveals that the responding authorities are in no position to take effective steps to consider the case of the petitioner, taking into account that there is a status quo order passed in WPC number 856/2013. Accordingly, this court therefore directs the instant writ petition to be listed again on
856/2013 has already been disposed of and the order is enacted. 856/2013, this was the reason initiated that did not consider our petition.
Yeah.
It is at page number 41. When you made an application initially, they said that there is a status quo order. Thereafter, we filed an application seeking improvement in that case. Matter remanded to the deputy.
No, there's a problem out there. Na? There's some direction which has been placed that will be open for them to file appropriate legal proceedings as may be possible. Until such time the process as directed by this court is completed, the interim order dated so passed by this court shall continue to hold the field. Last time too. This court, however, finds it relevant to take note of that the writ petition, that is WPC number 856/2013, was disposed of by this court on 23/2017, wherein there was a direction upon the Deputy Commissioner Kachar, Silchar, to examine the claim of the petitioners therein, along with all other interested parties pertaining to any right arising out of the land in question, and thereafter pass appropriate order in the matter as may be necessary in the facts and circumstances of the case. The said exercise was directed to be completed within a period of 6 months from the date of receipt of the certified copy of the order. It was further mentioned that till such time, the process is not completed as directed. The interim order dated 22/2/2013 passed by the court shall continue to hold the field. This court therefore finds it relevant that when there was a direction by this court in the order dated 23/2017 in WBC number 856/2013 to complete the exercise within a period of 6 months from the date of receipt of the certified copy of the order. And more than 6 years have elapsed in the meantime. How the order passed in WPC number 856/2013 acts as an impediment towards the consideration of the case of the petitioners. The District Commissioner Kachar Silchar is directed to file an affidavit explaining the said aspect of the matter on or before the next date. List the matter again on 10th of January 2023-24. The affidavit be filed without fail by 5th of January 2024.
I'm developed.
The instructions for place is kept on record and marked with the letter X. Madam, you don't look into the petition and you are making that submission. Huh? You are saying that because of the pendency of so and so, whereas the petition has been disposed of.
And second, they have made a verification, Lordship, and it is found that petitioner on the non.
That is another, but the above instruction is wrong.
I told them that it has already disposed of.
Then, if you have told them, then also why you are placing this instruction? Hmm? You want to withdraw? Mr. I. Chaudhary, appearing on behalf of the petitioner, submits petitioner submits that he has instructions to withdraw the instant writ petition. Accordingly, the instant writ petition therefore stands closed on withdrawal.
Right.
You file the affidavit in reply? Why? What? Cost? His appearance fee today? Is unnecessarily appearing? 5,000.
I will file within 1 week. 1 week time.
1 year. Tomorrow, if you file it also,
Yes,
5,000.
Last opportunity, I will present.
This court filed an order dated 16/10/2023. Granted. The petitioner the liberty to file the reply. And accordingly fix the matter after the puja vacations. You are affected by the interim order?
Yes, your lord.
You vacate the interim order. Oh, I did not extend the interim order last time.
Yes, last time it is noted.
However, no affidavit has been filed by the petitioner. Be that as it may, the learned counsel appearing on behalf of the petitioner further seeks for an accommodation. Do you want to file a reply or not?
Yes, sir.
Further seeks an accommodation to file the affidavit in reply to the affidavit in opposition filed with respondent number 8 and 9. On the other hand, Mr. Jaisinath, the
NN Upadhyay.
NN Upadhyay, learned counsel appearing on behalf of the respondent number 8 and 9, submits that the petitioner is delaying the matter Taking into account the above, for the ends of justice, this court grants further 4 weeks' time to file the reply by the petitioner. Full stop. However, this court imposes a cost of rupees 5,000 to be paid by the petitioner, to be deposited by the petitioner before the registry of this court at the time of filing the reply. It is made clear that the deposit of rupees 5,000 shall be a condition precedent for accepting the reply on behalf of the petitioners. The registry shall, on application filed by the council appearing on behalf of the respondent number 8 and 9, the registry shall, upon an application filed by the council for the respondent number 8 and 9, release the said amount of rupees 5,000 to the said councils.
This is next case also. Same party, next case also.
Same problem?
No, it is a different matter. 21.
Lordship, affidavit is filed, Lordship, 23.
Only 2311.
They filed it.
I have filed affidavit in opposition.
You have filed?
Yes. As per earlier direction of this.
You have filed. So they are to file reply. You want to file it. The learned counsel appearing on behalf of the petitioner submits that the respondent numbers 10 to 16 have filed an affidavit in opposition on 23/11/2023 and 6 for an accommodation of 6 weeks for the purpose of filing a reply. To list the matter on 20/1/2024. In the meantime, the petitioners would be at liberty to file the affidavit in reply. You know, thereafter what happens?
Obliged.
Yes.
I don't matter, it with the payment of compensation. Last time, go to state to direct the understanding council PWD to obtain instruction.
Yes.
Lordship, so
What
far
is
as
the
my
instruction?
instruction is concerned, Lordship, construction work has been done by following the original alignment, Lordship. Initially, the petitioner remained silent. 50% of the construction is already over, but after she has alleged that this is her patta land, Lordship, construction is now stopped. And subsequently, Lordship, it has been reported to the circle officer and also to the ADC to demarcate and make an inquiry and demarcate the land if it is patta land of the petitioner, Lordship, and to follow the compensation process. That is the instruction. Last letter is of 14/11/2023, Lord.
No, there is a communication issued by the executive engineer PWR wherein it has been mentioned that if the petitioner's land falls on the aforesaid project, the land of the petitioner has to be acquired by the government. And petitioner is required to be compensated, for which the executive was directed to do the needful. The said instruction is kept on record and marked. The order seeks some instruction to obtain accommodation to obtain instruction as to what the petitioner intends to do with the land of the petitioner. Then
this is the latest instruction, Lord. When this letter was written to the ADC on 14/11.
Now, has the additional deputy commissioner done anything?
That instruction.
That instruction have to receive.
Now effective rate 70 Department of Property.
In pursuance to the order dated 10/11/2023 passed by this court, Mr. P. Nayak, appearing on behalf of the PWD department, submits that the executive engineer PWRD have issued an instruction to the additional deputy commissioner, bracket LA Borpeta, intimating the said officer that a part of the RCC building bridge with the approach road on Nogao Kordhora to Panisila Road was constructed over the schedule of the land measuring 1 bigha 2 katha 10 lecha, which was mutated in the name of the petitioner. And a request was made to proceed for necessary compensation as per the land acquisition process. This instruction is kept on record and marked with the letter Z. Ms. S. Borua, appearing on behalf of the respondent, appearing on behalf of the additional deputy, appearing on behalf of the office of the Deputy Commissioner Borpeta, shall apprise this court on the next date as to what further steps have been taken by the additional District Commissioner LA Borpeta pursuant to the communication dated 14/11/2023. List the matter again on 22nd of January 2023 on an update as to the present status of the land acquisition proceed as to present status of the acquisition proceeds. Plan. Right. Three.
Related to settlement of land, my lord, by an order dated 4/10/2023, my lord. Lord, may kindly peruse this office memorandum.
Yes.
In terms of this point number 1, my lord. The Deputy Commissioner of the district is empowered to take a decision in case of allotment of land in rural areas. So therefore, the approval of the department is not required.
After receipt of the approval of the subdivisional letter.
Yes.
What is this? Let's read point number 1 again.
1. The Deputy Commissioners of the district are authorized to allot land to the indigenous landless persons in the rural areas as per existing land policy after receipt of the approval of the Subdivisional Land Advisory Committee. After 3 years of continuous physical possession, the land will be settled with the allottees in the form of annual patta, provided that the land is found to have been used for the purpose for which it is allotted. Already allotted land
now
in.
Tell me one thing.
Yes.
Meaning thereby what? After 3 years of continuous possession means?
That will be settled. And initially allotment order will be issued.
No, can a person possess on the basis of allotment order?
But madam.
Can a person possess on the basis of allotment order?
Yes. Initially he will be given allotment order. He will, if he possesses that land and utilizes that land for the purpose of which it is given, then after 3 years on verification, if it is found that yes, he has utilized for the purpose for which it is given, then he will be settled. Initially, annual patta will be issued and then it will be
initially no. Initially you will be given
allotment.
permission to occupy. You see, these are
The
office
language-
memorandum.
Language is allotment.
These are office memorandums. Office memorandums cannot overshadow the settlement rules. The settlement rules provides a specific thing, which that day in our order also, I have made it very clear. The issuance of an allotment cannot be said to be a settlement.
Yes.
An allotment would be at best a permission within the ambit of Rule 16.
Yes, that, yes. Of
The settlement will be as per the issuance of a patta, annual or periodic, whatever.
Yes. Yes.
So you mean to say, what is, they will give a permission in terms of Rule 16 to occupy and remain in possession, and if they remain in possession for 3 years,
Yes.
then you can very well, you will issue the settlement by issuance of a patta.
For that in rural areas, that
The power is given to the deputy commissioner.
And as
So the deputy commissioner need not take the permission of the government.
Yes.
So Revenue and Disaster Management Department has no business.
Second. And secondly, my lord, as per land policy 2019, 1.3, it says that maximum for a rural area, it has to be 3 bigha. Maximum of 3 bigha for agricultural purpose, half a bigha for homestead purpose. Then 6 bigha may not be, perhaps his claim for 6 bigha may not be allowed.
I've asked you also to obtain your instruction. What have you done?
Instruction not received. What happened?
এখন কাগজখন ৰাখিবচোন বহুত দৰকাৰী হয় ফোনতে নেক্সট টাইম Yes.
Instruction have to take lordship.
Yeah. Who appeared? P.R. Mohanta. Where is she? She's not there to help you out.
I appear on.
Okay. You and who has appeared on your behalf? None has appeared. Pursuant to the order dated 4/10/2023, the Learned Counsel appearing on behalf, Mr. A. Bhattacharjee, the Learned Counsel appearing on behalf of the Revenue and Disaster Management Department of the Government of Assam, have placed before this court an office memorandum dated 2/7/2013, 13, which stipulates, which as per 13, it is the submission of the Learned Counsel appearing on behalf of the Revenue and Disaster Management Department that in respect to settlement of land in rural areas, the deputy commissioners of the districts are authorized to allot land to indigenous landless person in the rural areas as per the existing land policy after receipt of the approval of the subdivisional level land advisory committee. Thereupon, after 3 years of continuous physical possession, the land would be settled with the allottees in the form of annual patta provided the land is found to have been used for the purpose for which it was allotted. He therefore submitted that in view of the office memorandum dated 2/7/2013, the Revenue and Disaster Management Department of the Government of Assam has no role as regards allotment of land in rural areas, save and except the lands which comes within the ambit of clause 3 and 4, 3, 4, and 5 of the said office memorandum. He further submitted that as per the present land policy, the petitioner would at best be entitled to the present land policy of 2019. The petitioners would at best be entitled to 3 bighas of land as agricultural for agricultural purpose and half a bigha for homestead purpose. Ms. S. Purva, appearing on behalf of the Deputy Commissioner Dhemaji, submits that though this court had directed by the order dated 4/10/2023 to obtain instructions from the said office from the said respondent, but there has been no instructions received. Taking into account the above, this court fixes the matter again on 24th of January 2024, on which date the learned counsel appearing on behalf of the Deputy Commissioner Dhemaji shall ensure that the instructions are duly received. Councils, I will be only taking up after coming back only urgent matters. All other matters I'll be adjourning. Huh? So if you are not there, those matters will be adjourned. Only if anybody has urgency, I'll take it up. Yes.
In this matter, they did not take any interest since the starting of the case till 23/1/23. On 23/1/23, Honorable Chief Justice Personal Order, you will be allowed to take and see. It was a personal repairs, others to calculate the amount. Then they calculated it.
When?
23/1/23.
Who is appearing for the respondent?
Since that on 20.
Oh, that is okay. Thereafter, you have got the money, na? Now we are only concerned with the interest.
Interest also. In there, thereafter, they have calculated it. The calculation is on order 23/23. 23/23. Calculated. Since they are taking time for this 8 months, but not paid the amount.
My lord, I've taken the instruction. We have MSCT budget, which is any movement come, my lord, but at least 4 weeks time may be granted.
It's a case of contempt. Withdraw, initiate contempt proceedings.
Also, it is once given.
We paid the principal amount, my lord.
Who is this?
Only the interest part is there.
Only the interest only we are concerned. It is 5,94,000. Who is the managing director of the Assam State Electric Transport Department? Who is to pay?
The person's not there, no longer the pipe.
Yes,
Okay, who is the person who is to pay?
MD.
It's MD, man.
MD.
But he's not a party man.
From 20
We, on the basis of the undertaking given that the payment would be made, we make the
The lordship maybe keep it in the Monday, my lord. I think
No,
so.
nothing doing. It is not done. You have on 23/2023, you have said that the amount is to be paid is 5,48,343 as interest.
Yeah. Yeah.
Almost 8 months have passed by. 8 months have passed by. Why haven't you done that?
But there's
Every time you have been taking the same thing.
a budget, my lord.
Understood,
MBCT
but
budget.
can this budget be in this manner?
So we are
Continuing?
facing financial constraint, my lord.
Understood. Then you have anything which can be sold?
The property, my lord.
Which property?
Any property, my lord.
We
is
attach
this-
it. Which one?
Lordship may.
No, you are the standing counsel also for the case. Tell me, which property you have? We'll take it up after some time. Get the details of the property, we'll attach it for the putting it in state. We attach because it is after all the duty of the ASTC to make the payment. That non-compliance has not been affected.
I
You
understand,
can't
my
hold
lord,
the persons responsible for not payment because they can't. But the payment is to be made by ASTC.
Yes.
The compliance, they can't do anything if the ASTC doesn't have the money. So under such circumstances, how do this court affect compliance? The only way is to sell off the property. What about that Polton Bazaar property?
That has been, I think, my lord, given to railways. Because now ASTC has been shifting from there. Because railway is taking the ASTC entire that area. My
So railway have acquired that land.
yes, there's an agreement, my lord, between the railway and ASTC, and they have, in lieu of that, they got another land somewhere else.
Who?
ASTC. But they have surrendered that land to railways, my.
They have?
They,
Did they receive any consideration?
I don't see anything. This is government.
So which land they have got?
They got land somewhere, my lord. Distance, my lord. I have to find out.
So ASTC has no property within Guwahati.
What did they have? They should be having. My
Which
lord.
one?
Rihabadi, they have. That is, they have that. Yeah, somewhere the land is there. Lordship, take it tomorrow, my lord.
No. We're passing this order now. The instant contempt proceedings have been initiated. For non-compliance with the order dated 12/2/2013, passed by this court in WPC number 6165/2012. This court had perused the said order dated 12/2/2013. Wherein there was a direction that as regards the claim for interest, the respondents may examine the same in accordance with law. Wherein, apart from deciding the entitlement as regards the principal, there was a direction that as regards the claim for interest, the respondents may examine the same in accordance with law. This court, the petitioner being aggrieved, for non-compliance to the order dated 12/2/2013 in WPC number 6165/2012 have initiated the instant contempt proceedings. It appears from this court, from the records of this court, that on 8/2/2019, notice was issued on 28/2018, notice was issued by this court. At that relevant point of time, when the contempt application was filed, the respondents herein were the officials who were responsible in the day-to-day affairs of the respondent corporation. Be that as it may, the said officials are no longer holding the post in the respondent corporation. As has been submitted by Mr. J. Roy, the learned senior counsel, appearing on behalf of the ASTC. It further reveals from the records that the petitioner have already received the principal amount of rupees 7 lakhs. And the question of payment of the interest was the issue. This aspect of the matter was recorded in the order dated 22/1/2020 by this court. When the matter was listed on 23/1/2023, this court permitted, at the request of the learned standing counsel appearing on behalf of the ASTC, to work out the part of the amount which is yet to be received by the petitioner, failing which it was the opinion of this court that the concerned person would appear before this court. Thereafter, when the matter was listed on 16/3/2023, no such instructions was forthcoming from the ASTC, for which this court again fixed the matter on 23/2023, enabling the standing counsel for the ASTC to obtain instruction and apprise this court regarding the amount receivable by the petitioner as interest. It further reveals that on 20 March 2023, the standing counsel for the ASTC apprised this court that the interest of component works out to rupees 5,48,393.42. And this court granted 6 weeks time to place necessary instructions as regard disbursement of the interest component to the petitioner. Thereafter, the matter has been listed on various occasions, and the standing counsel appearing on behalf of the ASTC has been seeking for time on the ground that the ASTC is running to financial constraints. From the above facts narrated, it transpires that the liability to pay the amount of rupees 5,94,000, 48,393.42 to the petitioner is upon the ASTC. From the submissions made by Mr. Roy, the learned standing counsel appearing on behalf of the ASTC, it transpires that the officials of the ASTC is not in a position to state, taking into account that the ASTC is state as to when the payment would be made, taking into account that the ASTC is not in a position. It is under great financial distress.
MSCT budget, my lord. MSCT budget is due.
Financial distress. Under such circumstances, as the liability is on the ASTC, and there is a requirement that the order passed by this court also is to be complied with. It is the opinion of this court that the entitlement of the petitioner cannot, therefore, and it is the opinion of this court, that the petitioner cannot be deprived of his entitlement. And the matter cannot be delayed, which have been already pending since (2012), and when it cannot be further delayed, taking into account that the petition was filed as far back a decade back in the year 2012. Therefore, this court fixes the matter on 18/12/2023. Now, this court further sought for instructions from Mr. J. Roy, the learned counsel, as to what are the properties available with ASTC, which could be sold, auctioned, attached, for the purpose of realizing the said dues, and also as to whether there is any bank account of any head of account of the ASTC in which the said corporation receives its dues, which could be attached. Mr. J. Roy, the learned standing counsel, submits that he has no instructions in that matter, but submits that he would take appropriate instructions in that regard. This court, therefore, fixes the matter again on 18/12/2023. On which date? On 18, the managing director of the Assam State Transport Corporation is directed to file an affidavit by 13th of December 2023 stating the following. Number one, the head of account in which the ASTC receives any amount. Number two, the accounts both current and savings of the ASTC. Number three, the list of movable and immovable properties of the ASTC. Full stop. This court, however, makes it clear that in the circumstance that the amount of rupees 5 lakhs 48,393.42 is released on or before the next date, the requirement of the said affidavit would not be required. It would be dispensed with. List the matter on 18/12/2023. You get the money, don't worry. Yes.
CTS is available, last occasion he was absent.
Oh, yeah. Here the petitioner claims to be entitled to some amount. As per Water Resource Department, he is entitled to the said amount, but the Water Resource Department is to pay 10% and 90% by the Ministry of Jal. And as such, on the one day when the matter came up before this court, when all these things was happening, I said that how can this court pass an order without Jal being a party? So therefore, Jal was made a party. Now, with Jal being made a party, now this court gets the authority to issue a writ for 90% so that he gets the amount and then you pay.
In fact, these are the amounts under the flood management program, for which this subject has been a subject of litigation before also, and in a batch of petitions. The state government was to submit a supplementary budget within a specified period, and on submitting that, it has to go to the central government, and they were supposed to release the money. I do not know whether if this falls within that.
Now, this is what, therefore, for compliance for an effective order in the terms of 27/9/2022 was which was passed by Justice Sham.
Yes.
The requirement of Jal was there.
Yes, yes.
Therefore, I made Jal a party out here. Two and I. So we pass a similar direction to the effect. The instant writ petition has been filed by the petitioner seeking an amount of rupees, seeking a direction upon the respondents to pay the amount of rupees 73,21,168 within a fixed period of time, along with interest thereon. The record reveals that the petitioner, who is a Class 1A registered contractor under the Water Resource Department of Assam, was awarded a contract for re-allotment against cancellation of scheme inverted comma R/S to T/Dike along both banks of Kopili River for Sarai Hagi to Tuklai Tup bracket L/B bracket close Basundhari to Killing Des Kopili junction L/B bracket close and Sapormukh to Agatguri Amsoi PWD road bracket R&B including R/B bracket including anti-erosion measures at different reaches. Paragraph 2 that's there. The petitioner states that the petitioner completed the work in time and after due inspection and measurement, the concerned division prepared first running bill number RA/I/MG/3364 dated 31/12/2018 for an amount of rupees 73,21,168 and submitted before the concerned authority for payment. However, the said amount was not paid.
I think work order may be mentioned, man. Work order.
Huh?
Work order number may be mentioned. Work order, man.
Work order number is what?
Yes, the annexure, I have seen paragraph 2 also it is there, my lord. Annexure 8 is 11 also it is there.
ऊपर की लिख ले ऊपर. Who is a class 1 contractor was issued a work order bearing number MGWRD/3/2014-15/58 dated 27/1/2015 to execute the contract work that is re-allotment against cancellation. Huh? It is the further case of the petitioners that the petitioner have approached the respondent authorities time and again. But the said amount was not released, for which the petitioner has approached this court. By filing the instant writ petition seeking the relief as aforementioned. This court duly this court, upon perusal of the materials on record, perusal of the materials on record reveals that on 26/3/2021, notice was issued, making it returnable by 4 weeks. The respondents, however, have not filed an affidavit in opposition.
But we have instruction.
Be that as it may, on 4/10/2023, when the matter was listed, Mr. B. Goswami, the additional advocate general or the standing counsel? Additional advocate general, also representing the water resource department.
For all the state respondents. For all the state
For all the state respondents, submitted that the issue involved is covered by the judgment of the coordinate bench of this court dated 29/7/2022, passed in WPC number 4734/2021. Be it as it may, as at that relevant point of time, the Secretary, Ministry of Jal Shakti, Department of Water Resources, River Development and Ganga Regeneration, New Delhi 110001, was not a party to the instant proceedings. An interlocutory application was filed, which was registered and numbered IA number 3140/2023 for impleading the said authority. This court, by an order dated 16/10/2023, impleaded the said authority, that is, Union of India, represented by the Secretary, Ministry of Jal Shakti, Department of Water Resources, River Development and Ganga Regeneration, New Delhi 110001 as a respondent number 6 to the instant writ petition. On the same day, the Standing Council appearing on behalf of the Miss S. Purva, the Central Government Council had also accepted notice. The said newly impleaded respondent number 6 have also not filed an affidavit in opposition. It had been, be that as it may, Mr. Archidep Chaudhary, the learned DYSCI SGI, submits that the issue involved in the instant writ petition is covered by the judgment passed by this court dated 27/9/2022 in WPC number 54734/2021, and appropriate directions may be issued in terms with the said judgment. This court, upon hearing the parties, now, this court have duly perused the order passed by the coordinate bench dated 27/9/2022, wherein it was duly observed that there was no dispute about the fact that the petitioners therein had in fact executed the works, and their claims have also not been disputed by the departmental authorities. It was further observed by the coordinate bench that since budgetary provisions have now been made, recently, the said writ petition, along with others, were disposed of by issuing certain directions. Today, when the matter has been taken up, Mr. B. Goswami, the learned additional Advocate General, has placed the instructions before this court to the effect that there is no denial to the fact that the petitioner is entitled to the amount so claimed. And in that regard, has submitted an instruction which is kept on record and marked with the letter X. It is further seen from the said instructions that the estimated amount of the scheme under which the petitioner had worked, petitioner and various other contractors have worked, was rupees 11062 lakhs, and out of which 90% was supposed to be borne by the government of India under the central share, and the remaining 10% was supposed to be borne by the government of Assam under the state share. It was further mentioned that the total bill value of the petitioner against all the work orders issued against the scheme was rupees 14 crores 47 lakhs 60,804, and out of which the payment has been made proportionately for rupees 4 crores 83 lakhs 66,979. it was mentioned that the full payment could not be made to the contractor. As the payment had not been received by the Water Resource Department from the government of India. But the department is taking all necessary possible steps to our release of the fund from the government. The said instructions though makes it clear that the petitioner is entitled to the amount, to certain amounts, but it is, however, not clear as to whether the petitioner is entitled to the amount so claimed in respect to the work order in question. Therefore, taking into account the order passed by the coordinate bench dated 27/9/2022 in WPC number so-and-so, this court disposes of the instant petition with the following directions. Number one, who shall do? The chief engineer? Verification? As to exact
yes.
amount?
Chief.
The chief engineer, Water Resource Department, Guwahati, is
So
officer.
far verification is
Huh?
concerned. So far verification part is
Verification.
concerned. Yes, chief engineer, one.
What? Who is the respondent number?
I think two,
Water Resource Department.
two.
Two. Is directed to make verification as to whether the petitioner is entitled to the amount of rupees 73,21,168 as claimed in respect to the work order in question. If upon verification of the said amount, it is found that the petitioner is entitled to the said amount or any part thereof, it is the opinion of this court that the petitioner is to be disbursed the said amount of his entitlement. This court further directs the said verification be carried out within a period of 1 month from the date a certified copy of the instant order is served upon the Chief Engineer, Water Resource Department, Guwahati. Number 2. Upon carrying out the verification, if it is found that the petitioner is entitled to the amount claimed or any part thereof, the Chief Engineer of the Water Resource Department shall, within 15 days from making the said verification, communicate the supplementary budget passed.
In fact, so far supplementary budget is concerned, in fact, at that relevant point of time, all the amounts were included in the supplementary budget. Then only, my lord, it was placed for the central government.
Then what to do with him?
My lord, according to him, my lord, that part, he so far this work is concerned, he has not received, my lord. His claim is, my lord. But the budget state government has given.
We'll do anything. We don't say anything about the supplementary budget. We say that we shall communicate to the Ministry of Jal.
Yes.
And, yeah. Upon carrying out the verification, number 2, upon carrying out the verification by the Chief Engineer, Water Resource Department, within the time as stipulated herein above, the share of the petitioner and finding out that the petitioner is entitled to that the amounts of claim or any part thereof, The chief engineer PWD, the Water Resource Department shall communicate the same to the commissioner and secretary, to the additional secretary of the Water Resource Department,
Additional chief secretary in charge of
the Water Resource Department, so that the 10% of the amount of the share of which the Water Resource Department of the government of Assam is liable to pay is dispersed to the petitioner.
May point out one. So for total amount is concerned, my lord.
I am coming.
Yes.
The said be done within a period of 60 days from the date of completion of the verification. As regards the remaining 90% of the amount, which is the share of the union of the government of India, that is the respondent number 6. The additional chief secretary in charge of Water Resource Department, State of Assam, shall duly communicate to the Union Ministry of Jal Shakti for release of the amount due under the scheme to the Water Resource Department of the State of Assam and the secretary to the Ministry of Jal Shakti of the Government of India is further directed upon receipt of the said requests being made as directed herein above to release the said amount if not already released to the state government, and upon receipt of the said amount by the Water Resource Department, the same be released to the petitioner. This court further directs that after completion of the verification in respect to the share of the union of the Government of India, the authorities so directed shall complete the same within a period of 90 days, therefore. With the above, the instant petition stands disposed of. The instructions so placed by Mr. B. Goswami is kept on record. The photocopy. Yes, any more urgent matters? You see, the problem is I need to sign. I can't. I'm leaving tomorrow. Any urgent matters?
Item number 27. Otherwise, I don't have any urgency.
Then don't
the department may have some urgency because it's a case of afforestation, compensatory afforestation. They have identified a place, my lord, in lieu of my place, my lord. On last occasion, my lord.
Oh, that matter.
Yes, my lord. They have clarified that stand, my lord.
That they are sea forestry or something.
Yes, yes, sir. Compensatory afforestation.
Then
they have clarified their stand, my lord.
We have filed our affidavit, Lord. We have filed our affidavit.
So then, if they file the affidavit, what happens? You are not affected.
Because they have reviewed the place, madam. Now they are. They have identified another location, madam, for compensatory effort.
Now we'll record that affidavit, and accordingly we will say that nothing remains. That is it. You are only aggrieved that they are going to infect you.
My place, madam. Now they are identified different place. Paragraph 3 of this affidavit, case 43.
Yeah. The instant writ petition has been filed. But the petitioners herein challenging the decision for allotting land of Nabdi Dalogoku village of the Mahasau district for compensatory afforestation in connection with implementation of 120 megawatt Lower Kopili hydroelectric project at Longpu, as well as for setting aside and quashing the impugned letter dated 6/2/2021 issued by the Secretary, Revenue NC Hills, requesting the Chief Conservator of Forest Dimahasau to shift Nabdi Dalagupu patch of land measuring 86.23 hectare for compensatory afforestation in connection with implementation of 120 megawatt Lower Kopili hydroelectric project at Longpu. And this court, by an order dated
5/10/20
1/6/2021, issued notice thereby directing that the status quo as regards the petitioner's village for the purpose of compensatory afforestation in terms with the communication dated 1/6/2019 shall be maintained. When the matter was listed on 30/8/2023 before this court, this court directed both the Forest as well as the NC Hills Autonomous Council to file their affidavit in oppositions by 25/9/2023. It further reveals that pursuant to the orders passed by this court, the respondent number 5 had filed the affidavit in opposition on 3/10/2023, wherein it was mentioned that there was a letter issued by the Additional Secretary Revenue to the Chief Conservator of Forest Dimahasau dated 11/9/2023, which clearly reflects that in connection with the implementation of 120 megawatt Lower Kopili hydroelectric project at Longpu to a different location, which will be identified shortly in Dimahasau due to some unavoidable circumstances. Wherein it has been mentioned, wherein there was a request made to the Chief Conservator of Forest Dimahasau district, requesting the latter to shift the Nabdi Dalagapu patch of land measuring 86.23 hectare for compensatory afforestation in connection with implementation 120 megawatt Lower Kopili hydroelectric project at Longpu to a different location, which will be identified shortly in Dimahasau district due to some unavoidable circumstances. It was also mentioned in the said communication that after identification of the plot, the land shall be allotted to the Forest Department immediately for compensatory afforestation. Under such circumstances, when the matter was listed before this court on 5/10/2023, this court, taking into account that the affidavit filed by the respondent number 5 was not clear, that they would not proceed with the compensatory afforestation at Nabdi Dalagopu village at measuring 86.23 hectares of land, thereby amending the proposal sent on 1/6/2019. directed the respondent number 5 to clarify their stand by filing an additional affidavit. Accordingly, on 20/11/2023, an additional affidavit was filed by the respondent number 5 stating at paragraph number 3 that the land measuring 86.23 hectares situated at Nabdi Dologupu was earlier allotted for compensatory afforestation for implementation of 120 megawatt Lower Kopili hydroelectric project. The said proposal was reviewed by the council and now Nabdi Guru Bari (Ziri) will be allotted for compensatory afforestation in regard to the aforementioned project. Mr. C. Sharma, appearing on behalf of the NC Hill, submits that in view of the specific undertaking given in the additional affidavit to the effect that the petitioner's village, that is Nabdi Dologupu, would not nowhere be affected, the writ petitions so filed by the petitioner have become infructuous. This court, having perused the materials on record and having taken the specific, having also considering the submission made by Mr. C. Sharma, the standing counsel for the NC Hills, is of the opinion that the Nabdi Dologupu village, wherein the petitioners are residents, is of the opinion, finds that now Nabdi Dologupu, which is the village of the petitioners, would not be affected, as the proposal which was given on 1/6/2019 have now been, in so far as Nabdi Dologupu village have been modified and some other village have been allotted for compensatory afforestation. Accordingly, the instant writ petition espousing the cause of Nabdi Dologupu village no longer survives. Accordingly, the issues raised in the instant writ petition in respect to Nabdi Dologupu no longer survives, for which the instant writ petition stands closed as infructuous. The interim order, therefore, no longer survives in view of the above observations. No more?
Complete.